Brother Das, you are there?
Yes.
We have concurred with the opinion. We have dismissed the repetition.
Again to WBC 7106 of 2020.
No infirmity in the opinion, repetition is dismissed.
WBC 91 of 2020.
Time to go. Repetition has been dismissed.
May it pleases your lordship. Lordship, I beg to mention for adjournment item 12, your lordship. Here, yesterday we have circulated adjournment note. The arguing counsel is not available today, your lordship.
Okay, when do you want?
Next week, your lordship.
Next week. On a request made on behalf of Ms. Lee Ghost, learned counsel for the petitioner, matter is adjourned to be listed on today's 10th. We can have it on 17th. Is it okay?
7, yes, your lordship.
17.
Deeply obliged. Please, lordship. My lord, item number 18,
18.
lordship.
Supply list.
Lordship.
Yes.
The IAA has been listed for correction of order, lordship.
Hmm.
My lord, may I pray for upgrade the matter, lordship?
Upgrade is difficult. Orders. What kind of correction?
Lordship, the district of the respondent, that is SP, should have been Borpeta. It is written Baksa.
This bench.
Bozali, lordship.
This
Yes,
bench.
the bench constituted by Honorable Court number 6, lordship. Not this bench. But
Okay,
the FT bench, lordship, please.
okay, we'll have it as a first item.
Obliged.
Late because lordship, with regard to item number 8 and 9, lordship, lordship, this matter will be taken up at 2, lordship.
8 and 9.
Personal appearance, even.
No, she was a petitioner in person, but today I have appeared.
At 2 o'clock. Who's for the other side?
I'll inform the other side.
Don't have to inform them. We may not reach also. There are, we will reach. If FT matter starts, there are matters of 19. But we'll try to have it. Not in the first half.
2 o'clock, lordship. Hello.
We'll find an affidavit capable of
In which matter?
in item number 15.
15.
Yes, ma'am. Supply.
19 matter.
Yes, ma'am.
What affidavit?
Some document I have been placed.
Okay, very good. But can you file an affidavit without a permission, leave of the court? Was leave granted to you?
Monday I mentioned.
No, was leave granted to you? 19 matter without a leave. There is a procedure for filing pleadings. Unless we grant leave, at least you have to make a prayer. It may be an oral prayer on
Monday I make a prayer.
Monday made a prayer.
Yes.
Emotional.
Monday matter was listed.
Monday matter was listed.
my lord. Then I took time.
Let us see, bring it. Let us see.
Item 18 upgraded.
May I please, Lordship? My lord, earlier, Borpeta and Bozali was the same district, Lordship, Borpeta. The matter was tried in the tribunal, Bozali tribunal. And we have made the Bozali SP as party, Lordship. But after this interim order, the petitioner appeared before the SP Bozali, wherefrom he is instructed that he has to appear before the SP Borpeta because the records are there with SP Borpeta law.
Lordship, this correction has to be made in the main writ petition also. That has not been corrected.
That prayer also we have made, Lordship. In the IA, Lordship, that prayer also.
Because in the main writ petition, it is only.
Yes, Lordship.
Bojai.
They have written Bojali.
They have written.
So it is
You
not
can
the court's
go
fault.
in Both the districts, Bojali and Baksa both.
No, my lord, it is not a court's fault due to confusion because earlier both the districts were same, Lordship. After bifurcation, this confusion has arose.
Okay.
I
You are M. Hussain.
am I Hussain, Lordship?
Am I heard? Three M. I. Hussain, learned counsel for the applicant petitioner. Also heard Ms. Sohasabalik. By the instant application, comma, the applicant has sought to correct the addresses of the respondent numbers 5 and 6. Full stop. It is contended that while in the aforesaid addresses, comma, Bojali was written, comma, after passing of the interim order, it was the petitioner, the applicant came to know that the record are with the Superintendent of Police, Borpeta.
No.
Full stop. Para. Ms. Verma, the learned sending counsel, though has not seriously objected to the prayers made, has submitted that the petitioner applicant had lacked due diligence as proper party was not arrayed. Para. Be that as it may, and in the interest of justice, we are of the opinion that the corrections is required to be allowed. Full stop. The petitioner is accordingly allowed. The petition stands. The petition accordingly stands allowed, and the petitioner is required to submit corrected memo of parties in the writ petition. Full stop. We also clarify that in the order dated 1/6/2026, comma, the expressions Superintendent of Police Borpeta Bojali should be read as Superintendent of Police border Borpeta. B बोलिए सर जने कैसे लगे
Border Bojali.
border Bojali असेल border B Borpeta बोलिए you have time to appear.
Lordship, I appeared.
Appeared
I
already.
appeared. I am directed to appear before SP Borpeta, Lordship.
But within 10 days.
Lordship, 10 days today expired, Lordship. Then time may be extended, Lordship.
At this stage, comma, the learned counsel has submitted that the applicant petitioner had appeared within the specified time before the SP border, Bojali, where he or she, he was directed to appear before the SP border Borpeta full stop para. Accordingly, accordingly we extend the date for appearance before the SP bracket border Borpeta to another 10 days, which is to expire another week, which is to expire on today's 10th, on 17th, on or before 17th.
Deeply obliged, Lordship.
Supposed to expire on 17th. I stand disposed of. You get the certified copy today itself.
Lordship, obliged.
Until one.
May I please, Lordship. My lord, this is a contested case. Your Lordship may kindly find the impugned order at page 76.
16 to 2022.
Lordship,
Why are you so late in coming?
Lordship.
It's a contested matter.
Yes,
Heard Sri M. I. Hussain, learned counsel for the petitioner, who by means of this application filed under Article 226 of the Constitution of India has put to challenge an opinion dated so and so, passed by so and so, in case number so and so, whereby the petitioner has been declared a foreigner post 1971. Full stop. It is contended that the relevant factors have not been taken into consideration by the learned tribunal. Para. On the other hand, Ms. A. Verma, the learned standing counsel, Home Department, has raised the issue of delay in approaching this court. Para. Be that as it may, let notice be issued, returnable on 15th of July, 2026. Union of India, Ms. Asad B. Chakraborty, B. Chakraborty, that is CGC for one, and
6 and 7.
Ms. A. Verma 2, 6, and 7. Election Commission of India, Ms. S. Kotoki.
G. Sharma. He's there.
For G. Sharma. Extra copies. Just a call for the records, huh? Refer office to.
5.
Oh, 5, okay, yes. P. Sharma, 5, State Council. Obliged.
Item 2.
May I please the lordship? Lordship, petitioner is declared foreigner by the impugn order dated 7/8/2025, my lord. Impugn order is at page number 125.
What are your grounds of challenge?
My lord, here, my lord, the PW1 has is the brother of the petitioner, my lord. He deposed in the deposition, my lord, that he and the petitioner has casted vote in the year 1977, my lord. But though tribunal has not accepted that, my lord,
77 voters list was approved.
my lord, it is exhibited, my lord,
Proved or not?
my lord,
That was not considered.
no, my lord,
What is your name?
PM Ahmed.
P.M. Ahmed, Miss P.M. Ahmed, learned counsel for the petitioner who has filed this petition challenging an opinion dated 7/8/2025 passed by so and so, in so and so, whereby the petitioner has been declared a foreigner post 1971. Para. The learned counsel has submitted that relevant factors, including the deposition of the brother of the proceeding, have not been taken into consideration. Para. Let notice be issued. Returnable on 15th of July 2026. Union of India, B. Sharma, B. Chakraborty, 1. Election Commission 2, S. Kotoki. State of Assam Home Department 3,
6.
3 and 6, A. Verma, 4, G. Sharma, and 5, P. Sharma. Extra copies are again call for the so Miss Ahmed, the learned counsel praised for an interview. SP what?
Gwalpara, my lord.
SP border Gwalpara. We have to appear on or before. On or before today is 10th. On or before 19th of June. Okay. Hey, line to Pisarkin on or before within 10 days on or before 19th. Correct.
Applies me.
You serve extra copies.
Yes, ma'am.
May I please, Lordship? My lord, here Lordship will find, my lord, impugned opinion at page 101, my lord.
Very recent.
And my lord, operative part lordship will find at page.
What are your grounds?
Lord, basically, my lord, the evidence of the father was not considered by the learned tribunal. Father says she is my daughter.
What is what about the documentary support?
School certificate was proved.
Who had proved?
The school headmaster.
Headmaster had come
My lord.
as DW.
My lord. DW3.
Okay. Part 3 MU Mondol counsel for the petitioner who has filed this petition under challenging order 9/3/2026. Good taken actually for declaring foreigner, but it is contended that the evidence of the father as well as the school certificate have not been properly considered. Para, let notice be issued, returnable on 15th of Baki Sabak, 15th. Who will take the accept notice? Union of India, Chakraborty. Why are you at the back, Mr. Chakraborty? You should be at the forefront. Bharat Sarkar. Bharat Sarkar has to be invited. One election commission, Ankalita. Oh, Ankalita on behalf of AI Ali. 2. 2 and 10. Who's 10?
ERO.
ERO, 2 and 10. Then 3. Chief Secretary is P. Sharma, 3.
4, 6,
3 and 9. And A. Verma, 4.
6, 7, 8.
4, 6, 7, 8. And
G.
G. Sharma for 5. 5 extra copies. Call for the record. They can take a look. Office to requisition or interim. And then a cassette for you. You appear on the same basis. What a question. What did we say? 19th?
19th.
19th. On or before 19th.
1906.
Mm.
Deep blood.
10,000 of which SP border?
My lord, SP border Dubri.
Dhubri. 10,000, huh?
Oblige.
Item 4.
May I please, Lord? My lord, contested case, my lord. The opinion at page 91. Opinion dated 22/4/2026.
22.
91 page.
26.
Okay, hard 3 SA Ahmed, huh? Almost like we have order date to 22/4/2026. What are your grounds?
My lord, grounds the voter list as and the elder brother of
Ex parte.
SDW2. No,
Ex
it's
parte.
contested case.
No.
Yes, she failed to prove her linkage, my lord.
Yes, madam. The learned counsel for the petitioner had contended that relevant factors, including the evidence of the
DW2,
who's he,
he is elder brother of the petitioner.
including evidence of the DW2, evidence of the elder brother as DW2 have not been properly considered. Issue notice, huh? So returnable ke hobo. Union of India, B. Chakraborty CGC 1, Election Commission, Ms. S. Kotoki 2, Home Department, Madam Verma for 3, 5, not 5, 3 and 6, 4, G. Sharma, and 5, District Commissioner P. Sharma. Baki khine ke. Okay, bail, huh? Which SP?
My lord, SP border Golaghat, madam.
SP border Golaghat, You appear on before, or not before, same date, 19th of June, 10,000 bill.
Obliged.
বড় লেগে গেছে কি আর?
Again 17, so please.
May it please your lordship, my lord, ex parte order 29/4/2025, annexure A, page 11.
15, 16 কি হলো? Oh, it was 19 or okay. Yeah.
Lord,
Yes, madam, you are not appearing on the other day. We are waiting for you.
I'm sorry, my lord. As in port number
We saw you, then you disappeared.
in port 10, I was.
Against which,
Yes.
what is the date of the?
29/4.
29/4/2025, ex parte order, my lord. Petitioner could not produce the document, my lord. However, she was, because, my lord, in the year 82, my lord, 1982.
But you had appeared.
But could not file WS, my lord.
Then why should we grant you time to file WS?
My lord, because some document, my lord, I could, but kindly see, my lord, I have some admit card, my lord, then school transfer certificate, everywhere, my lord, my name, my father's
The
name is
admit
there.
cards were pre-existing documents.
Father's
What is the
name-
reason for not filing those documents
My
along
lord,
with the written statement?
Because, my lord, petitioner was born in the district of Lakhimpur, my lord. But in the year 2001, my lord, she married in the district of Bishwanath, my lord. Because of sense of this, my lord, her documents was with her parents, my lord. She could not produce, my lord. So,
References of which year?
17.
Huh?
17, my lord.
17.
And someone was given in the year 2024, my lord.
So you need 1 year to have the documents in such a serious matter.
My lord, I have all the documents, my lord. I will produce, my lord. One chance may be given, my lord. Kindly see, my lord, father of the petitioner, whose name is appeared in
We are
the
not on
file.
those aspects. We are not in the merits. We are on the merits of your case, whether the expert decision is bad in law or sustainable in law.
My lord,
You are given a chance, you neglected.
my lord, because of the, my lord, some miscommunication with the advocate, my lord.
Where have you stated?
My lord, she could not produce, my lord.
Where have you
Kindly
stated?
see. Names of the, my lord, there are 6 petitioner was served upon one summon and asked to appear before the foreigner tribunal on 22/1/24, and petitioner in compliance of the said notice appeared before the tribunal on the date fixed and sought time to file her written statement. However, the petitioner on subsequent dates had to sought for time to file WS as relevant documents which relates to her parents are with the parents, and some could not be traced out during that period of time. Therefore, again, my lord, on 17/3/2025, petitioner have sought an adjournment for filing WS, but learned tribunal by this order dated 17/3/25 fixed the matter for ex parte hearing, and accordingly matter was decided ex parte.
See, there is a mandate to complete the proceeding within a specified time. You are given a chance to contest. You neglect to contest. What should the tribunal do?
Yes, sir.
Give you chance after chance? Or should the tribunal abide by the law which mandates completion of a proceeding within a particular time?
Because of the change of address.
Interfering with this order would amount to interfering with the law which has been complied with, followed by the tribunal.
My lord, one sense, my lord, all documents she have, my lord, because she was from district Lakhimpur and married to Vishwanath district, and documents are with her parents.
What is your age?
43, my lord.
These are not convincing at all, this so-called reasons.
6.
There
6.
are
6 opportunities.
6 opportunities, yes.
Only one opportunity.
Hmm?
Only one opportunity.
Why is 1? 6, we are giving 6 opportunities.
My lord, because of that, my lord, because she married to another place, documents are with parents.
It's not that she married just 2 years back. And she.
When was the marriage?
Friends lot.
2001, my lord.
2001, okay, marriage is okay, but what prevented you from getting the documents from your parents' house, home?
But she was an illiterate person, my advocate also did not deal well.
Where you have not stated? You have
All
not
document-
stated all this.
My lord, she has all done.
You're not an illiterate.
She
You sign in English language.
appeared.
You say you are illiterate, you may have been uneducated, but you see your signature, beautiful handwriting. Unless somebody else has signed for on her behalf.
Documents are there, my lord, for one son, my lord. Kindly see all here had a father named Arman Ali.
She's
Kindly
not
annex her,
almost
say-
lordship. She's not illiterate.
See her signature. It may not be there in your.
She has a higher secondary certificate also.
Oh,
lordship.
illiterate.
No, 10, my lord,
Just
10,
six.
10.
10 is illiterate.
My lord, 2001,
What is the meaning of
my lord.
illiterate?
2001, my lord, she left all this, my lord, that's right. Kindly see, my lord.
Lordship is not illiterate. Lordship has given enough time, sufficient of the chances were given to her. It cannot be.
That I admit, my lord, but yes, I have all the documents at present, my lord. One son, only one son may be given.
Let us see the opinion. What is the opinion?
My lord,
Opinion.
When lordship annexure A. The T-voter lordship, it looks like a T-voter case. Being the full case and it was registered sometime in 2006. Reference was in 2006.
Okay. Madam, dismissing.
Lord, one of person there, see, her father name is appeared in voter list of 65,
Yes.
my lord.
As Bora, learned counsel for the petitioner who has put to challenge an opinion oblique order dated 17/3 29/4, and you have come to this court after 1 year.
My lord, she did not have the knowledge. When my lord, police went to her
No,
house,
lordship
then
said
only.
The proceeding.
No. Not, she appeared, my lord, this
29/4,
judgment of
2025 passed by
knowledge
the
of judgment, my lord.
passed by the learned so and so in case number so and so, whereby the petition has been declared a foreigner post 1971. Full stop. The primary contention of the petitioner is that she could not contest the proceeding and which culminated in the ex parte judgment, ex parte order. Para? Miss, we have heard Miss G. Agute hilu niki?
Yes, Bora.
Kolo niki agote?
This,
Okay. Miss Bora, the upor hote ifalo likhiba. Also heard, huh? What? Miss Bora, the learned counsel for the petitioner has submitted that there were vital documents which would have a relevance in the adjudication process, and due to certain circumstances which were beyond the control of the petitioners, the said documents could not be collected, which are said to be in the parental house of the petitioner. Full stop. She has submitted that a chance may be granted to her to contest the case. Para. On the other hand, Ms. A. Verma, the learned standing counsel, has strenuously objected to the prayers made. Full stop. She has submitted that the petitioner had neglected to contest the proceedings in spite of the fact that she had appeared and took time for filing written statement. Full stop. She has also contended that the proceeding of the present nature cannot be an endless exercise, and the learned tribunal had been considerate enough and had granted several opportunities, in spite of which the petitioner had neglected to appear. Para. The learned counsel for the rest of the respondents have endorsed the submission advanced on behalf of the Home Department and has prayed for dismissal of the writ petition. Para. Perusal of the impugned order would clearly reflect that upon receipt of notice, the petitioner had appeared before the learned tribunal on 22/11/2024 and had filed the petition, taking time to file the written statement. Full stop. However, no written statement was filed, and on the other hand, petitions were filed on the subsequent dates, namely 20/12/2024, 18/1/2025, 18/2/2025, and 17/3/2025. And on each occasion, the learned tribunal had granted time to the petitioner to file the written statement. Full stop. The learned tribunal has also recorded that as many as 6 occasions were granted to the petitioner before passing of the order dated 17/3/2025 to proceed ex parte. Full stop. Para. The reasoning recorded, the reasons recorded by the learned tribunal in the impugned order appears to be cogent and in accordance with law. Full stop. We are prima facie of the opinion that the impugned judgment, impugned order does not suffer from any infirmity. Full stop. However, taking however, in the interest of justice, we are of the opinion that since the petitioner contends that there are documents which are presently with her, an opportunity be granted to the petitioner to contest. Full stop. At the same time, we cannot be oblivious of the law holding the field which is laid down in the Foreigners within Tribunals Order 1964, where there is a mandate for completion of a proceeding within a period of 60 days. Correct? 60 days. Full stop. For any reference, order 3 within bracket 14 is extracted here in below, page 161. Where we are also of the opinion that negligence having prima facie been established, the scope and opportunity to appear has to be subjected to a cost to be paid to the Gauhati High Court lawyer so and so. Para. Accordingly, the writ petition is allowed and the impugned order dated so and so is set aside with a direction to the petitioner to appear before the learned tribunal on or before on or before 23rd of June. We have the good enough, no? 23rd of June 2026, along with a written statement and evidence on affidavit of all the witnesses and the documents. Full stop. On such appearance, the learned tribunal would accept the same and proceed and would take charge of the proceeding from the said date. Full stop. As noted above, the learned tribunal would make an endeavor to complete the proceeding within the prescribed time. Full stop. The present order is however subjected to payment of a cost of rupees 5,000 in favor of Gauhati High Court so and so, huh? It is also made clear that if the petitioner fails to appear along with the other requirements on the date specified, comma, the order in question dated so and so would revive. Question one, opinion order, huh? Opinion question dated
29/4.
29/4/2025. Okay.
Which petition is this supposed to?
15.
Now the improving opinion is page 24. Hmm? Yes, I will. Yes, sir. I can organize it.
Which page?
Well, page 24.
24.
24.
Dated 29/6.
Yes, well,
17. FT
FT.
third.
Yes.
Morigaon.
Morigaon.
Yes.
Here, you'll also find this page, next page 25. Exhibited documents, madam.
You come to the documents.
Exhibited documents, now, you'll also find this exhibited document, exhibit page 29. His father and one brother, a case was registered against them, that they have been declared as Indian.
Madam, take a seat. Do not stand. Yes. You're an intern or what? Student. Have a seat. Don't stand.
Okay, I'll go to it also. I'll go to it.
Show us the document, Mr. Ahmed.
Page 29.
29.
Yes, madam. It is
This is another opinion.
father and against his brother. This is the distinct copy, my lord.
It's okay. Father and brother were declared to be
Declared
Indian.
in India, my lord.
So you need to contest on your own on your own strength, on your own. See, declaring them to be foreigner will not cause any prejudice. Vis-a-vis, declaring them to be Indian will not make you Indian.
Yes.
You have to contest on your own. All references are specific in nature.
Yes.
What are your documents?
This document place in that case. I also next here. You also can listen next page. Page 31. This is the voter list
Of
of
1966.
1966. My grandfather's name was there. It was exhibited as exhibit 2 And it was exhibited in earlier proceeding as exhibit co.
Doesn't
Page
matter, doesn't
30 Page
matter.
32.
Exhibit two,
Yes, well. Exhibit 2,
this is 1966,
1966.
voter list.
Voter list. well.
Who's there?
Qasam Ali, grandfather.
Grandfather,
Yes, well.
28.
well.
Which village?
Then my lord, page 33.
Village,
My lord.
village.
Oh, village, my lord, it is Tumukabadi. Mauza Mikirbita, then district of Nagaon.
Okay, thereafter,
Thereafter, exhibited document is page 33, as exhibit 3. Original page 34. My father name appeared,
which one? 1989.
1989.
Name of the father?
Abbas Ali.
Abbas Ali.
Well, this document also exhibited in earlier proceeding.
Hmm.
Now, 1997,
Page.
page 36.
Your father was 37 years in
Uh,
1989.
1989. In 1997, it was shown as 55 years. Page 36.
Who is Mujibur Rahman?
My brother, elder brother. His against his also proceeding was initiated. In the said brutal list, my lord, in the said you also kindly see serial number 1307 to 1310. In between names are not there, and I found that his mother's name and uncle's name also appear in that brutal list. But those are missing here. That is why I filed one additional affidavit to show just to show that their name also included in the 89 brutal list, 91 brutal list. Mother's name. Now let's kindly see page 38. 2005.
No, where is that affidavit?
Hold on. Not yet come.
Not yet come.
Not yet come. Now look at kindly see page 38.
You have you given the equation?
Yeah, because
Okay, well, let it come. We'll continue with this.
page 38.
This is of which year? 2005.
Right. My father and my brother.
Age remains same.
As they mentioned. As they mentioned. In this brutal is also serial number 98 my father, serial number 102 my brother. In between my mother name, my grandfather's name, and my uncle's name also included in the death brutal list. And in the 205 brutal list, my name also appeared. I annexed it, my next.
Which page? 1340? 40?
42. Page 42.
No, what is 40?
My lord?
2011.
Yes.
Let us go serially then.
Yes, sir.
40 is what?
40 is 2011 brutal list. Exhibit 6. Page 40.
Abbas Ali.
Abbas Ali, my father, and Mujibur, my brother. In between, 4 names has been not mentioned here. My father's name, my name also appear in the voter list.
In 2005 voters list, the spelling is different, both in your respect as well as your father's. Abbas
Abbas,
and Kasem.
Kasam,
It was Kasam.
Kasam.
Age also remained the same.
No, 62.
No, 55.
No,
In comparison to 97 voters list.
in 2005 voter list, my father's age was 55.
97 also it was
Yes,
55.
What is the village? Name of the village at page 40?
Page 40 village is Colopia.
Huh?
Colopia.
Holopia.
Colopia, Parliguri, two villages are there. I belongs to Colopia place.
And your father was in Tumukabari? Grandfather?
Grandpa Tungavali. His name appeared in 1966, 1970 also. Now let's look at say page 41, 42. It is exhibit 7 of my case. 205 voter list. Again, here my name appear serial number 103. Khairul Rahman. And if you lordship revisit the page 38.
Shaidul is you.
Yes, ma'am. If you lordship revisit the page 38.
Yes, please.
Here 102 my brother Mujibur Rahman and 103 my name. House number 12.
But why your name was not along with your father's in 2005?
Here,
No, 2005 voters list. Here
Yes,
you are alone.
alone, they get separately. My house, your loss of page 38. 98 serial number my father, house number 19.
Acha.
And my brother's name appears as serial number 102, house number
98.
98. Hello. It is wrong actually, it is 90. And your loss of is my voter list, page 42. Serial number 102, house number 19. House number 19 is separately given. Voter list given separately.
Separately দিব পারি না, একেলগে লব নোৱাৰিলে।
They should the voter list, entire family member. Well, we applied, they should given the entire voter list of the entire family members, they not furnished. Now, Gauhati certificate he was not examined, page 44, exhibit 8. Now, can you see page 46, those documents we could not place before the terminal below, page 48, 46. 1970 voter list of my grandfather. Kasomal. Single voter list. Now 2011 voter list, this was also not my place before the terminal below. And later on I obtained. You also can see here. Here 99. It is correctly there now furnished. 115, 119, 120. My name is there. 2011 voter list.
No, you are at page 46. Page 46. You are,
Page 46.
what is page 46?
Page 70 voter list of my grandfather. That was exhibited in earlier proceeding.
This is 1970.
70,
What did you show at an earlier point of time? 66.
66. I could not place this document before the terminal.
Oh, that was not placed.
I mentioned in my petition also. Now 2011 voter list, my lord, it was also I could not place entire voter list. Now I place here before the lawsuit. Page 48. My name appear along with my father, my brother. Page 48.
This was also not placed.
In 11th place, where my father and brother's name appear,
This was not placed.
not placed.
Abbas Ali to বেলেগ হ'ব। Abbas Ali আর কসমটো বেলেগ হ'ব।
কসমৰ বাপেক আছে।
Possession,
কসমৰ ঠিকে আছে। কসম আৰু এই আব্বাস ঠিকে আছে। এইটো পিছত যে আব্বাস আৰু কাছেম আলী হ'ল।
আগৰ কথাৰ লগত আমাৰ কথা নাই। We have to see a link of the petitioner with immediately link with the father. It is আগৰখিনি চব ঠিক থাকিব। Your endeavor is to be to show a link between these three persons.
my lord, page 38.
No, 48, let us see, 48, what is 2011?
Yes, my lord.
Abbas
Abbas.
Kasem Ali. Abbas is your father?
Father, my lord. He expired. Now,
Who is Saidul?
Saidul is Michael.
Or your Saidul?
Michael.
And Mazibur?
Brother. Who was declared as Indian. Now let's say again my lord, page 40.
40.
40.
2011.
2011 because that document has been exhibited as exhibit 6. Here only two names, my father and my brother.
Yes.
My name should have been incorporated in the said Gudali, but not incorporated. So that is page 40. That is why I often a fresh copy and place before this honorable court. Same document, same cell number, same house number. No. Then page 50, my lord. This document also I could not place before the tribunal. 2014 voter list. Listen.
2004, who are there? Abbas is there.
2014.
14, Abbas is there.
Yes, my father is there.
Father.
My brother and myself.
But your father's name was never with your grandfather in any single voters list. Your father's date of birth?
Date of birth I cannot say.
Your date of birth or year of birth? (1984), Mr. Ahmed.
Hello.
How many DW?
35 years in 2019. 35 2019. Now around 7 years. Around 42 years ago. Now we'll also kindly see the affidavit count. Let that affidavit count.
How many DWs did you use?
2.
Who were there?
Myself and my uncle, Abid Ali.
DW1 is petitioner.
Yes, madam.
And 2,
Who is my uncle?
uncle.
Yes, sir. Abid Ali. His name also appeared along with my father and grandfather, but in the voter list, not furnished. That is why I placed this additional affidavit to bring on record that. So just to convince the court that their name also appeared in the said voter list. Same house number. Now, like I said, the evidence of my lord, page 14. If you look at page 16 is the copy. itu পবিত্র ভাই evidence progress চলো কেটে আছে এটা
চাই গম পাই যে বাপেক জন্ম হৈছিল 52 তেতিয়াহ'লে 72 he is eligible বৰ বাপেকটো নানাইটো ঢুকোৱা নি তেতিয়া সিহঁতৰ 40 লিষ্ট চেলো নেকি এতিয়াতো এই বাপেকটো আহিছে দাদাজী
Is your father alive?
No.
When did he pass away?
2014 or 15 in
Huh?
2014 last part of 2014 he mentioned here. In evidence he stated. At least it's low, so I say first.
2014 around, your father had passed away.
Yes, but 14 or 15. I will find out.
Now, what do you want to show in page 16?
16? Oh, affidavit, man.
Yes.
Evidence.
Of DW1. DW1.
This will did one.
Yes, madam. Additional
I have. Instead of have.
served to whom?
Okay, the text will be not.
Ranjit Gogoi has taken for FT. Learned standing counsel for ECI are not available at present.
I now, sir.
And as such, notice could not be served today. Copy will be served to the learned counsel.
I will, sir. I
Yeah.
have already, sir, today.
Okay. And for state, somebody has already. And this notice has been sent by one Madam Hasiba Gul Daisy.
Yes.
And yours faithfully is Rajia Begum. Two names. Alias.
No, different.
Different.
Yeah. পরীক্ষা একমাত্র
Not identified both. DB. আমার দুটো নাম নয় আইডেন্টিফাই করা না কেন তুলতে হবে ডিবি 96 না ডিবি কার হবো একটু গম না পাই না গেছেন আর 96 to we were sitting
F10.
10-6
What is this endorsement on the backside of the notice?
কিনে গেছে হ্যাঁ
Not identified, DB is not identified. What is this?
Huh?
No, we are just curiosity.
I understand the
You can have a look, some new method. What is it? Backside. Mr. Sharma is also very interested. Show it to him also. Ji Sharma.
yes but she said a letter and she identified
Now, what is this? What is the meaning?
not identified boot
Means who has not identified whom?
Yes. Identified, but
Hmm?
one reserve identified. She identified.
No, at the backside, we are just last page, last
Boot,
page.
yes, I see. I have seen. Not
Who has written this? Mr. Sharma, have a look.
filing section. Filing section.
Filing section.
Filing section.
দুটা নাম দিলে ন সেইকাৰণে গৈছে চাগে ন
কি করা যায়?
Maybe it was a piece of paper where you had noticed something. It's then converted into a notice.
Sorry, my lord, sir.
But today's date is there. Date is there.
Yes,
9/6 Easter day.
10-6 is there see in the upper part
Oh, yes. Then again
3:55 p.m. is yet to reach
Sorry, my lord, for
No. It may not be her fault or your fault. Some filing might have given some endorsement. We have not understood actually. Who's not identified? Okay, please continue.
Right.
16, page 16, DW1.
page 14, my lord.
Page 16.
Original. I am OB1 in the instant case. My father, Abbas Ali, is arraigned as OP2, but he expired last year. Evidence taken on
2016, August 2016.
16, the 15, 2015. yes.
16.
No, last year.
That is evidence taken on 16. That means 15 he
Last
passed
year,
away.
15 months.
Yes.
I read,
studied
studied up to
class 4
class 4. My father is also originally from Colombia. My father casted vote in 1989, and my grandfather customarily casted vote in 1966. My brother, namely Mujibur Rahman and father Abbas Ali, were declared as Indian in the application was so and so. It is wrongly, it should be 27. In original, it is within 2020. It should be 27.
Doesn't matter. Therefore,
So now, my lord, the exhibited document, my lord. Judgments, so and so, those are exhibited documents.
where is the evidence?
This is
There is no evidence.
it is a correspondent.
No, where is the evidence? You have just referred to a judgment and said that the judgment has been passed for your father and your brother. That by itself will not amount to discharging your burden.
That, no, we exhibited it. That judgment we exhibited.
Judgment will not discharge, your burden will not be discharged by a judgment passed in some other proceedings.
Yeah.
You have to establish your own case.
So I give the evidence by exhibiting that document as exhibit 1. That document has been exhibited as judgment exhibit as exhibit 1.
Judgment will not determine your case.
Fine.
And vice versa. Even if your brother has been declared a foreigner, that itself will not make you a foreigner.
My lord. My lord.
It cannot cause prejudice to you or cannot get advantage. It can be a relevant factor,
Yes, other document.
but it has to be supported by other relevant documents
My lord.
and your own evidence. You have not adduced any evidence. You have
Right.
simply referred to the judgment, then voters list of Mazibur and Abbas, then matter ended.
Then my lord, page 18, cross part, my lord.
Cross.
Page 19, the original. My father expired a year ago. My mother, Jovita Khadija, is still alive. We are 3 brothers, namely Mujibur, Sheikh, and Majidul. Mujibur is working at Kerala since last 6 months. I have studied up to class 4. I have 2 paternal uncles, Hasan Ali and Abed Ali. Abed Ali is settled in Tezpur and Hasan Ali stayed at Colombia. Abed Ali left Morigao 20 years back. My grandfather is Kasam Ali. Now we have landed property in the name of the father. The land document is not eligible number. The original is page 19. Now DW2, my uncle Abed Ali.
This, in fact, page 19 does not appear to be cross. It appears to be an extension of your chief.
Or note.
Or no, it's not cross.
Page 19, top minus.
Hmm.
Form of recording division. Division of DW1 within bracket cross.
Oh. Totally has cross.
You're right.
The
Now-
illegible portion is land document is of Abed's wife.
It is not.
Huh. That is of Abed's wife, his brother's wife.
Hmm.
Huh.
Abed's wife.
He,
He came here only to cast vote for him. Hassan is not remain
married.
married. Now evidence is page 21. Page 22 is the original number. Obis Huidur Rahman is my nephew. Being son of Abbas Ali. Being my
DW2 is your uncle.
uncle. Being my elder brother. He expects some 1.5 years back.
Paternal uncle.
Paternal.
Father's brother.
Father's brother.
Okay.
Due to illness, I did not know whether any other FT case or except the present case one. My nephew is an Indian citizen, Central Cross. My father expired some 40 years back. My mother is Laljan Bibi. My grandfather name is Wasid Ali. We are 3 brothers. Abbas Ali, petitioner, father of the petitioner, Hasan Ali, mentally undeterred, and 3 self. My mother has 3 sons, namely Mujibur. My brother has 3 sons, namely Mujibur, Saidul, petitioner, and Majidul. And daughters are Saleha and Fatima. I have
5 children.
I have 5 children: Zahirul, Azibul, Ali, Manul, Hasibul. The landed property are in the name of my brother Abbas Ali. Landed property. That document was not placed before the tribunal value. That is why I find this situation very big.
But then DW once said that the landed, although it is in the name of the father, but what do you say? Though we have landed property in the name of the father, but land document belongs to Abed's wife.
But cross party is also something.
It is in the cross only.
Now here DW2 is
Oh, acha.
DW2. That document not placed before the tribunal bill. No. Just orally. Now also kindly see for a moment, for just consideration of my additional eligibility.
But whatever documents are there and before us, you have not proved your case.
The
I
linkage.
prove linkage with my father is stabilized.
Where is the statement? There is no evidence. You are trying to make some arguments on the basis of voters list, which were not even there before a tribunal. That is okay. You are trying to bring it
No,
here.
no.
Now, where are the statements that this is the voter list, this is my father?
No, 2005 voter list and 2011.
No,
voter
where
list.
is the deposition? Where is the evidence? He has said nothing. He has simply referred to a judgment and thereafter for documents. Then and how has he referred to the documents in such a cursory manner?
It was some kind of
Just-
page
just
page
repeat.
14, page 14, my lord.
No, come to page 17.
17. My lord. Total list of Mujibur and Abbas.
Yes, I am.
Yes, sir.
See, this is his evidence. Is there any evidence on affidavit?
It is on those days.
No. Is there any?
Oral evidence has
No,
been taken.
that is okay. No, we are not. We are only.
He has
trying-
taken oath. He has taken oath.
Had there been any other evidence, then we'd have considered. Now here, this is the only evidence. Kindly see, page 16.
Okay.
I am OP number 1 in the instant case.
Yes.
My father Abbas Ali is
Arrayed.
arrayed as OP number 2 and he expired last year. I studied up to class 4. My father is also originally from so-and-so. My father casted vote in 1989. Grandfather Qasem Ali casted vote in 1966. My brother, namely Muzibur, and father Abbas Ali were declared Indian in FT case number so-and-so. Exhibit 1 is the judgment.
Sure.
Then
Now, other
exhibit 3, 4, 5, 6, voter list of Muzibur and Abbas.
Abbas.
Not yours.
And exhibit
7,
7,
voter list of who? Who is this? Das.
it is my voter list.
Mhm.
Exhibit 7 is my voter list.
Of what? Voter list of DA? Oh, DW1.
Yes.
DW1.
It is
DW1.
my voter list.
And exhibit 8 is the Gauhati certificate. Gauhati did not come.
Not come.
So that is out.
Yes.
The voters list of 2005, exhibit 7. Let us again see exhibit 7. Exhibit 7 is which
It page 42. That is, I pointed out that, let's see, page 42, serial number 103, Saidul Rahman, minor. And exhibit page 38. Page 38. My fathers, my brothers. 102 is my brothers. 103 my.
But where is the link with her ancestor in the voters list before 1971? Only you have placed those 6670 where your grandfather's name is shown, projected. But there is no link with your father and your grandfather.
My lord, my uncle deposed. Sufficient. My uncle stated that he is my nephew. I am the son of Kasam Ali, and Abbas Ali is my brother. Sufficient, my lord. Sufficiently.
That is not sufficient. Again, you have to show by documents. Oral evidence is not sufficient.
69.
Oral evidence is
When
to
did
be,
your- when
oral
did your-
evidence is to be accepted if not dispute. No dispute, my lord. It should be accepted. There is no law that oral evidence should not be accepted.
There is a law.
In foreigner's
There is
case.
a law in
In
foreigners
foreigners
case.
case.
In foreigners
But,
case.
but
Not
this-
civil, these are not civil disputes.
yeah, but
And
but
your,
in
your,
federal
your,
judgment-
your argument, we have 100% we would have agreed with, had it been a civil dispute.
but
But in a case of foreigners, tribunal case, where section 9 is.
but
is
federally
there-
yes, it has been clarified.
No, but so we go
It
to
has been
the, we
clarified.
could, we go to the parent case, Sarvananda Sonwal. When is the requirement of rebuttal evidence? Only when there is a necessity. We know we know our limitation.
My lord,
Law is very confined.
my lord.
Now here, see, there's one issue here.
But 205 total is linked with my father. And since my father is an Indian, my uncle is an Indian, my entire family members are Indian. So I should be an Indian.
No, that logic, there is, if you give that logic, there is nothing to say. Your uncle, your father is Indian, why should you be a foreigner?
My lord.
We are only interested to know how have you linked yourself with this person called Abbas Ali as your
Abbas.
father? That is the question.
Mm.
Link yourself, get out of it.
So my evidence, I say I am the son of Abbas Ali. This is the, and my uncle says I am his nephew, and Abbas Ali his brother. Those are the evidence, and there is no other evidence. Now let's kindly see some documents for your kind review, my lord.
Just a minute, please. Exhibit 2 and 3 are from the same village, same address.
Exhibit yes,
Page 32 and 34
yes. Sorry, yes, 32.
and
Yes,
34.
same village, my lord.
Same address,
Colombia.
same address.
Yes, same address. 97 also, 36 also same village.
What is column number 2 house, Mr. Sharma?
House. Column
Column
number
number 2
house.
is house.
Yes,
In a voter's list, column number 2 is house.
yes,
Column number 1 is serial. Now, column number 2 should be house.
the house.
What's so much, watch it.
But Abbas Ali, son of Kasam Ali, কৈছে, but then
Welcome to
page number 34.
the village Khalapia of Heloguri. It is
Itu tukum kabri kiba.
village body. That village.
Tumukabari,
Tumukabari.
Islampur.
Oh, this is next is village. So how do you link this? Oh, Kholopia. This is Kholopia. 34 is Kholopia.
Except 70, 60 voter list, subsequent voter list adjacent.
In the written statement, where is the portion whereby you have stated that your father had shifted from Tumukabari to Kholopia?
No.
That is one issue.
No statement.
Because we have to link with a document which is prior to 1971.
Man.
There is one document of 1966 of Kasam Ali, whom you say that he is your grandfather.
Man.
So we have to see whether you have established a link. Kasam Ali's son is Abbas Ali.
Man.
There is no common voters list. And the only voters list of Abbas Ali is of the year 1989 when he was already 37 years old.
Yes.
You have not stated when your grandfather has passed away. There may not be a common voters list. Your grandfather might have passed away. But Abbas Ali ought to have had a voters list prior to this 1989. And this 1989, most importantly, is of Kholopia, whereas 1966 is of Tumukabari. Different village.
His grandfather died in 1976. He to 1972 one of the eligible. 1972.
Actually, my lord, 89,
52
89 is 37.
21.
Oh,
After 89.
তেতিয়াহলে 73 he ভোট দিব পৰা হ'ল 76 ত grandfather মৰিল he got 50 years back father died it was DW2 এ কৈছে so DW2 he কৈছে হেৰি my father died around 40 years back DW
As per
Hey,
total
my
is
father
1989,
40 বছৰ ধৰি ধৰো এতিয়া কি 1976 ত মৰিছে grandfather চাগে এটা ভোটাৰ লিষ্ট নহ'ব লাগে 3-4 বছৰতে মৰিলে
ঠিক আছে কিন্তু ৰেটটো চেঞ্জ হৈ গ'ল জেগাটো চেঞ্জ হৈ গ'ল
Yes. 15 ৰ কথা ক'তো পোৱা নাই where is the written statement have you annexed
yes, ma'am. Page 11, ma'am.
ক'তো পোৱা নাই 15 ৰ কথা আৰু মজুৰিৰ নাটকৰ কেছটো বেলেগ সেইটো আৰু বাদ দিম ন anyway that will not
In
affect
89 voter list, my age is 37. So I am eligible vote in the year of 1972 only.
yes 1973 or
But
not I, your father.
your
my father. Yes.
Hmm.
So necessarily my father's name should not appear in the 1972 voter list.
72.
1970 voter list.
He cannot come within 70
70, we are not asking 70.
Yes.
We are only asking
In between,
to show a link between Qasam and Abbas.
my lord.
because Qasam perhaps died in 1976
My lord.
You have not stated.
but then those
See-
things are not stated
My
or
lord.
the change of place
And if you Muhammad judgment or copycat option as article of the system.
Right, I admit it. Well, I admit it. No is mentioned in the written
Why
statement.
there is a necessity to mention? Because see, this written statement has been filed sometime in the year 2020, 2016 or 17,
Same thing.
16.
16.
In Sarvananda, what has been stated, we have been reiterating. I'm just
2005.
indicating.
2005.
What are your requirements?
No, Lord, it is not mentioned. Yes, sir. No one mentioned. Earlier, that is why some book has been published, circulated to the lawyers, how to draft, how to mention the foreigner's case matter. Thereafter, they are mentioned, now mentioning. Earlier, simply written has been filed.
Who has published the book?
My general myself written a book. Foreigners terminal,
That is why we have asked you who has published the book. You're also giving credit to your junior.
Hello. Yes, my junior.
You see? In paragraph 17 of 2005 SSA 665, there is good and sound reason for placing the burden of proof upon a person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section so and so of the. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. So in some cases, grandmothers
necessary.
would also be relevant.
I have seen it, but reason no have mentioned. That is I find on evidence. So can you just see the
Mention reference.
evidence for consideration? I try to. I just try to develop my law. I do nothing.
What have you given in the additional affidavit?
Affidavit, family list I have given. Page 52.
Additional affidavit is filed today,
Nah,
Yesterday.
Yesterday.
9. What have you stated here?
Right. I got to flip ahead again.
Mr. Sharma, have you got your additional affidavit?
Just now, I mean.
Or get it up. We'll take a break of 5 minutes. We'll go through the additional affidavit.
Paragraph 4.
5-2.
Page 52. Paragraph 4. With the family to this manner.
এই family tree টো আচলতে দিব লাগে most of them দিব লাগে।
নতুন file.
Evidence they stated about what in reading this number not stated. Now paragraph 6. Madam.
6.
Yes. Annexure B, local and this page 59. Those voter list, 89 voter list.
Hmm.
Page?
Page 61. 89 voter list. Here, also can see cell number 4243. My father's name Abbas Ali,
This is not certified copy.
not certified to be. It is a book money.
First, you are in the certiorari jurisdiction. We cannot see new documents. And secondly,
It is a,
even you have not given
it is
certified
not a
copies.
certificate. But I give a certificate to everyone. Page 59. Page
59.
59. 89 voter list. Page 60. Certificate copy, my lord. It was also annexed in the main writ petition.
This is
That
an
we
ex.
have already seen.
Annexed.
Hmm.
So I give this one just to be there is no time. Just I bring this and that similarity is there. Similarity is there. Only cell number 40 has been furnished, 89. But those 3 persons are left. Those are not furnished. Where my grandmother, my mother, and my uncle Abed Ali appear.
Where do you get those names? In the
Page 61.
no, at 62?
Page 62. There, my lord, page. Number 40, my lord. Then for the last down, my lord. Left side. House number 12. 40, house number 12. Abbas Ali, Laljan, Zobida Khatun, Abed Ali.
Who is Laljan?
Laljan, my grandmother.
Zubeda?
Zubeda, mother. And Abed Ali, my uncle.
No. Zubeda cannot be your. Oh, okay.
Mother, Abbas.
Okay, person. Okay, Abbas, okay. Abeda?
Abed Ali is my uncle. Actually, Abed Ali. Then on page 63, 97 voter list. 64 is the certificate to it was annexed in the main writ petition.
97, yes.
Page 64.
1997 voter list.
Yes. It was also annexed in the main writ petition.
Yes,
There's 64 the Lok Sabha candidacy.
64, yes, Abbas and Mazibur.
Monitor.
Yes.
Now it also candidacy newly complete copy my lord. There's 65.
Hmm.
Page 67.
67.
Left side, my lord, middle person, 1037 serial number, house number 411, Abbas Ali, Kasum Ali, 55 years. 1307, and their furnace could be 1307 and 1310. In between three names not when from this mother. Now 1308, Zobida Khatun, my mother. And 1309, Lanjan Bibi, my grandmother. 110, Mujibur Rahman is my brother. Hassan Ali, my uncle. 13212, Abed Ali, my uncle. When the site weight could be applied, they are not given the complete person covering the same house number. This could have furnished the complete voter list. Now 2005 voter list. So 68.
Page.
69 is the original.
Madam, how do you deal with these cases?
New documents cannot be introduced.
No, it's not a new document. He's trying to explain that in the certified copies which were obtained and exhibited, in those some selected names have been given. And only to fortify his submissions, he has also taken out extracts of the original voters list. That of course is not an evidence, only to show that the continuity.
Continuity is there.
That few names have been selected in the certified copy, but there are other names also. And to demonstrate that, he has given these copies. These copies, we are not saying for a moment that these have got any evidentiary value, but it puts emphasis or fortifies his submission that
The continuity.
continuity is there. So how do you deal with this kind of a situation?
Chip is examining the matter in the surgery. So had these documents been placed in the tribunal, Lordship would have,
Revenge back the matter.
because they have not placed it there and they're bringing in, basically it's a new fact before the court, Lordship. Even though there is a continuity.
No, why we have put this question, we have found many cases where new documents, entirely new, have been tried to introduce at the High Court stage, which we have discouraged. Now here, there is a rider, new documents which are directly connected with it's a entire copy
Yes.
of the document which has already been exhibited. And now there are many other names which were somehow not there in the certified copy.
For a certified copy, has they applied for a single name copy or for a complete copy? It is their application, on their application where certified copies are issued. We cannot put the blame on the office that only one name was given. Today, when I apply for my certified copy, it comes, if I say it will come with only my name. If I ask for my family certified copy, I put in the names, it comes complete. And this is my personal experience. He has to prove that he has applied for a complete copy, but he has got only a single name.
I make a statement in my review. Now page 69, you also 205 voter list. It was exhibited in this petition. Now subsequent voter list, page 70.
Page 70.
Page 70.
What is there in 70?
Page 2005, put a complete voter list. Every member of the same. Original list is 71. '97 serial number, my lord. Lanjan Bibi, my grandmother. Abbas Ali, my father, 98. 99, Zobida Khatun, my mother. 100, Hassan Ali, my uncle. 101, Abed Ali, my uncle. 102 Mujibur Rahman, my brother, 103 Saidul Rahman. House number 7, 19. Now you want to one vital document, my lord, page 74.
74.
And the copy is page 76. This is a land document of my father. It also could not place, although in evidence they stated, but they
No,
could
this
not-
should be a new document.
new document.
This cannot be equated with the other documents.
Yes, it is new document, my lord. But I just want to show that my father's name appeared in the Zongandi copy, and his name mutated in the year of 1993, subsequent. And after his death, our name has been mutated.
Where is your name? Saidul.
And illogically serial number, my father's name serial number 4, Abbas Ali. It was cutted. Laljan Bibi, my grandmother, cutted. Mojur Rahman 6, my brother. Saidul Rahman, myself. Majidul, my brother, another brother.
Let us see your this things remarks at
Yeah,
least
remarks, my lord.
76.
Yes. Chakra Bikrar, the last side, my lord. Chakra Bikrar 27/9/19 তারিখৰ নামজাৰি নং সোয়েংসু হুকুম মতে
Page.
page 76
Yes. Which one?
third column
Third. Yes.
খ চক্ৰ বিখাৰ সৰজমিন খ মাইল
Oh, yes.
চিধাৰ ইমান তাৰিখৰ হুকুম মতে পাটাৰৰ উক্ত দাগত খৰিদা দখল সূত্ৰে লালজানৰ স্থলত আব্বাছৰ নামত 1 বিঘা ইমান কথা মাটি নামজাৰি হৈ পাতাছন আব্বাছ আলী মাই ফাদাৰ
But Abbas purchased from
my
Laljan.
grandmother.
It's not inherited.
No,
Khorida Hutre.
passes. But they are the patada. Lanza, they are the patada.
No.
Four.
Father's link with grandfather has to be established because it's only the grandfather who has a voter list prior to 1971.
Yes, my lord.
Now this Laljan, he has purchased from Laljan.
Lanza, my grandmother.
Grandmother, he has purchased, not inherited. Reason?
So therefore, my lord, after death of my father, our name mutated in 2019 after opinion.
It will not clinch the issue, no?
So those are the documents, my lord, will see. I felt that matter will remain back, so we can prove all those documents before the tribunal below. A chance can be given.
Yes.
There
Yes,
is
already
Kasam Ali and Kasem Ali are the same person.
10%.
Anywhere in the written statement? No, it's not there.
No, it's not concerned.
Because Kashem Ali, it seems he died before 2005. So at the first place, your father's name should have been there with your grandfather in any voters list. But your uncle said he died 40 years before. Now, whether the same Kashem Ali, see, other
that-
voters list, late is first used in 2005.
No, that is why my grandmother's name not appeared. Because my grandmother name appeared in
No,
the land
yes.
document.
Kashem Ali is shown to have died before 2005,
Yes,
not before.
before 2005.
So when did he die? Otherwise, your father's name should have been there with your grandfather.
He might have been that before 80.
Then in that case, a common voters list should have been there. Father and grandfather. In other places, Qasam Ali is not shown to have died in 1987, 89.
Yes, madam.
Your lordship only decided in Allah some cases, we refer some judgment. Already your lordship decided to same judgment, and I
Now we'll record your judgments.
yes, madam. But I pointed out because you lordship already take a decision about those judgment. That is why it is my duty to place the negative judgment also, not positive only. Madam. Now, your lordship can listen for this too.
No, not completed.
Just that when I. Regarding written statement, not mentioning the fact in the written statement, I don't really, my lord. Clarified. Mm, 2021, 3 JLT.
Page
Page 85.
85. Name.
Hyderali versus
How do you spell HAI?
SAIDAR. Hyder Ali versus Union of India and others.
Paragraph.
Paragraph 24, 26, 27, 29, 33, 39, 41, 42, 46. All regarding written statement, non mentioning the entire fake written statement, all are mentioned here, my lord. Then, my lord, regarding age, difference of age appear in the voter list, my lord. Sometimes 45, sometimes up to 50, and sometimes same 50. In this regard, one WBC number 2926 oblique 2019
2926.
26.
Name.
Name Talebur Rahman alias Talu Munshi.
TA.
TALEBAR.
Talebor.
Talebur Rahman alias Talu Munshi. TALUMUNSI Munshi. Passes Istaba Assam and others. Inner Indian others. Decided on 22/10/2019. Here stated that discrepancies in age will not be significant if other parameters in evidence are similar. Here, residents all are similar. So in some voter list, 37 and jumping, abnormal increasing and again decreasing, and that has been discussed in that judgment.
Number 19 अपने doesn't.
And now another, and regarding evidence, my lord, oral evidence. Same, my uncle clearly deposed in the court that he is my nephew.
But in the last case, which Mr. Ahmed you have cited, Talebor,
Yes,
Talebor
Talebor.
on the discrepancy of age.
Yeah,
The rider is that other things have to be consistent.
consistent.
It is in the same
Same.
line of in the case of the Honorable Supreme Court in Sirazul. Sirazul. Other things have to be
No,
considered.
it is different, but here something is added. Because here in that case, I am also the lawyer in that case. In that case, in one portal is mentioned is 35. Subsequent after 2 years, 70,
No, understood.
45.
Age can be inconsistent, but other things has to be
Yes, yes.
consistent.
Here,
Same lining, same
Same line.
reasoning.
yes, here other things are.
Name may be different, but everything has to be similar.
But
consistent.
Here also, 89 onwards, all are same. All address, all are same. Just age and name may be some difference in name. Other parameters are same. In that also discussed. Now look, actually, since my uncle has clearly stabilized that I am the nephew of my nephew, so my relation has been stabilized. Since my relationship has been stabilized, so it had not been disputed. And moreover, no rebuttal evidence has been given by the state to controvert our evidence. That has been done. So in this case, Sujabali, 2021 4 GLT.
4 GLT
4 GLT 664.
SOJAB.
GLT.
No, SOJAB, Suzab.
Or Sujab. SUJAB Sujabali. MD Sujabali. Union of India and others.
Paragraph.
Paragraph 18, 19, 20, and 21. Then Ben Singh and another.
Bent you have
Lots have already discussed. So I refer it, because the proof of relationship. Section 50 and 59 of the evidence.
Man Singh and the Dolgovind.
And Dolgovind
Parisa.
Parisa. So those are the judgment I refer. And in Sujabali case, after considering all aspects of the matter has been went back to the tribunal below by giving a chance to prove this case.
What about oral evidence? What did it say?
Oral evidence, Dolgovind Pasa and Ben Singh. Oral evidence
Has to be backed with documents.
It is to be relationship has been stabilized. Relationship. It is those three has been regarding relationship. And oral evidence, hydroelectric case has been already discussed.
Definition.
In those such type of cases, we are also facing some unoffered situations. The parties come, they are not contacted with us. Last reason when matter is listed, I call him. Then I ask him, why those gap you are not? Then immediately I bring it to the state come, I file this matter. It is just I file this affidavit. So
Okay, we'll consider it, madam.
I will start from the birth of the petitioner's lordship. As per the affidavit, it is 1984. And as per his name in the voters list,
Madam, I may, sorry.
Yes, yes.
2005 voters list lordship, as per that, it would be 1987. May I draw lordship's attention to page 11, the written statement of the petitioner lordship. Lordship, in the written statement, he has nowhere mentioned about his brother, mother, sisters. There is no mention about his siblings or his mother's lordship. So he is supporting it now with the voters list and the various voters list which he has supported lordship. And the uncle who has appeared is DW2. His name also does not figure in the WS lordships. Lordship, the acquisition of the DW2 at page 21. uncle had very clearly said different things. He has said that OP Saidul Rahman is my nephew, being son of us, being my elder brother. He expired some 1.5 years back due to illness. I don't know whether any other FT cases are there except the present one. Though the same uncle had adduced evidence even in the father and the brother's case. But here he has not stated that before the court lordship. And he says, my nephew is an Indian citizen, so am I. And in the cross, he says, my.
No, what is the interpretation of that statement, that there is no other case? Let us see that part.
Yes, lordship, there's he's relying on a judgment of his father and brother who were declared Indians. Yeah.
I do not know whether any other FT cases are there except the present one.
Yes,
Oh,
uncle says that.
but November 16, when did he adduce evidence in the other case?
That is of 2013. The second opinion is of 2013.
Oh, it is now out.
Hmm. But in respect
It is
of
at page 29.
Saidul's effect,
When I do the son of sister,
Mm.
and there were two proceedings against them.
Mm.
I do not know whether any other FT cases are there except the present one.
No, the other FT is against brother and not father. He said he had a Saidul over time versus again.
Maybe. Maybe.
In the other opinion, they do not say the father and the brother has not mentioned that the petitioner is their brother or son. If he's relying on the opinion of the father and the brother, this is his brother's opinion logic. Brother has nowhere stated that he has a brother called Saidul logic. And here Abbas Ali is Abbas Ali, not Abbas, it is Abbas.
That can be held to be minor.
Yes.
Abbas and Abbas.
This uncle who has deposed in the petitioner's case, it says EW2, it is a sudden appearance only during the time of evidence. It has not been pleaded in the WS that I have an uncle or I have a brother
Hmm.
and they would be deposing lordship. The sudden appearance of the uncle, we will cite a judgment to that lordship. The lordship will even notice voters list of 1966, page 31. Voters list of 1966, page 31. It is of Tunka Badi. And it is a single name voter list again. And after that, after 66, he has exhibited 1989. From between 1989 and 1966, no whisper of why there is no voters list. He has not mentioned.
1970 he has annexed, but had not placed it.
Next.
No, here
Next.
it is, but it was not placed before the tribunal, I think. Page number 45.
Page 45 is afterthought logic. That
Hmm,
is
not
that is
placed
like
before.
obvious. But what he has exhibited must provide that between 66 and 89, there is no whisper, no voters list, whether they have been continuously residing in the state of Assam or not. And there's a shifting from 89 onwards. They are in another village, Mikir Bit or something else. So the first grandfather's voters list, there's no other.
No, before
voters list.
1989, that shifting was done.
Yes. There is no voters list to show the name of Abbas Ali with the Kashim letter. That is at page 31. Kashmir Mali, he was 28 years and 66. So his voters list ought to have been there. Some voters list with his son Abbas and Abed, both of them. My friend has not addressed this court on this issue that why there is no contribution, why there is not a 1970 voter list placed before the tribunal if they have it. It is only by 89. So 89 lordship will again see the names of the father and Abbas Ali with his elder son. And it continues like this, and now he's come forward with the continuity that lordship will consider, but these are extra copies. Even if they had this information, they could always have placed it before the tribunal. They have not done that. The Gaugura circuit and the petitioners voters list is page 41. He's exactly 18 years. According to this 2005 voters list, his date of birth would have been 1987. And as per the affidavit, it was 1984. So it's a single name voter list. And he has not given any extract copy to support this in the additional affidavit. Though he has brought in an additional affidavit with other names showing the continuity, the absolute voter list is not there to show the continuity in the additional affidavit. The other names are there, but his name with his family, his brothers, his sisters, who uncle has said there are 6 of them at page 21. There is no mention to that at all. At page 21, the uncle has stated that the petitioner have
21 is which voters list reference?
I'm referring to this voters list at page 41, where the petitioner's name appears for the first time at the age of 18 years.
Here, in this connection, only he's trying to project at page 69, read with 71 of the additional affidavit.
Petitioner with his family members, that is in 2005 when his name appears for the first time. 2005 is again, here also it is annexed a single name voter list.
No, first time he's 18 years at 2005. So
His lordship.
it could not have been before 2005. And what he has endeavored at page 69, read with 71 of the affidavit, additional affidavit. Kindly come to 71. He's just trying to lend support to the 2005 voters list. Only 2 names are there, to Abbas and Mujibur, but at 71, please see the serial numbers.
Yes, lordship. But then this is in 2005. It's an extra copy, lordship. We are not sure whether that
Now, that is the only reason we are think his submission is for a remand, that he may be allowed. Because certified copy, you may be right in contending that he could have applied for a certified copy of the entire family,
yes.
which he has not done.
And
But-
if I apply for a single name, my only voters list, I get only my name. I have to apply for the complete family's voters list, which he has failed to do. And he has shown the names of his sisters, lordship, where now when he was trying to connect, they have 3 sisters. They are all together 5 of them. Mozibur, Saidul, Maizul, and daughters are Saleha and Fatima.
5 children.
5 children, and that too has come from.
That means the petitioner along with himself are 5 siblings.
That has been deposed by his uncle, not by him. He has not stated about his sisters at all, lordship. In his deposition, he has said, my mother, Zubeda Khatun, is still alive. We have 3 brothers. Mazipur, self and Mazipur. Mazipur is working at Kerala since last 6 months. I have studied up to class 4. I have two maternal uncles, Hassan Ali and Abed Ali. This has not been stated in the written statement where he has to bring in all the facts within his knowledge in the written statement. Abed Ali settled so and so, and that my grandfather is Qasim Ali, who we have landed property in the Wiltshire. So he has not stated anything about his sisters in the written statement at all. Lordship. Not exhibited documents, I will not go into that, Lordship, because Lordship will consider in the Bampura certificate.
He has not emphasized.
Support my submissions, Lordship. First, I'll go through Sarvananda Sonowal, Lordship, having the written statement. That whatever is in the knowledge of the petitioner must be first brought in the written statement. So there is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence, his date of birth, place of birth, name of his parents, and their place.
This we have just read to Mr.
Yes.
Ahmed.
So I'm also relying on this. This is Sarvananda Sonowal, but this is SCC. This is paragraph 26. Lordship was in paragraph 17. There is some other citation. Then Lordship, I will rely.
Contents are the same.
Yes, contents are the same. Then I would like to rely on Momin Ali Lordship. Momin Ali is the sudden appearance of the uncle at
Moment only citation.
2017 to GAT 1076. Paragraph 12, 13 and 17, Lordship.
12.
12, 13 and 17.
There can be one answer to the question why his name was not along with his grandfather, his father's name not along. Because the uncle said that grandfather died 40 years ago. So if we take that into calculation, then we find that he died in 1976 somewhere during that period. So he became eligible to vote only in 1973 or so. So there's a gap of only.
Abbas Ali and Qasim are not together.
No, that is how they will not be together because only 3 years gap is there between his eligibility vote and the death.
What you can even consider after 66, the next voters list is 1999.
Yes.
In between, there is no, it is just a connect to that 66 voters list.
Hashem Ali.
It is just a connect, a paper trail made to show the connection, to show the linkage.
So since the grandfather died in 1976 and he became eligible in 1973 or so, so there was only 3 years gap between them. So may not be there any voters list. And so we are left with the voters list of 1989, where his father's name was shown along with his grandfather. So if this Qasim Ali is the same person whose name was there in 66, so then some kind of a link is established. It's a prima facie, subject to correction.
This is shifting.
Shifting, he did not say.
He has not mentioned shifting at all. It's silent on the shifting part completely. Silent on the knowledge he had. Whatever he has stated now, that was all within his knowledge, his place of birth. He may have forgotten the date, but he knows his place of birth. He knows how his brothers and sisters. He knows his father, mother, uncle. Nothing.
Those were not there.
Disclosed in the WS Lordship.
Mm.
Then, Lordship, I would like to rely on Noor Begum for oral evidence. 2023 GLT 347.
2020,
2020,
3 GLT.
3 GLT, 347. The oral evidence without support of documentary evidence is only in support of action. We are saying that he's my nephew or he's my father or uncle, but it not been supported by documents will not help him to establish his citizenship. And he's Lordship Bill, one more bit, now he's referring to the extract voters list. I would like to rely on one more specification for that lordship.
Hmm? 20,
2018 4 GLT 392.
2018,
4 GLT
3,
392.
name.
Borhan Ali,
Hmm?
BORHAN.
Borhan.
Borhan. Ali alias is Borhan Ali.
What proposition?
Lordship, it says that if a proceeding relies on a voters list, only a certified copy of such voters list or extract thereof would be admissible in evidence. Filing of an unsigned or unauthenticated or uncertified copy of voters list sought to be relied upon as a proof of citizenship would not be admissible in evidence. Now, which is trying to bring in the connect lordship, it is regarding that.
Paragraph.
Paragraph 21.7.
এতিয়া পৰা certificate copy বিচাৰিলে নাপালে হয় নেকি? Uncertified copy কিয় লাগিছে নহয় নেকি? দিব লাগিছিল, পালে হয়।
But this customer is new figures, but here is. There is some new documents which are available. This was a. In 97, lordship in the additional affidavit. It has placed the 1997 voters list. Abbas with Qasim.
97 voters list
Yes.
with?
Lordship just calculated. If he had passed away 40 years back, then this voters list would not have existed.
Oh, this one?
Qasim Ali and this Qasim Ali are one and the same person.
No, which would not have existed? 70?
No, this one. 97.
97 he's shown as the son of Qasim Ali. But then Qasim Ali is not shown as late.
Abbas Ali was about 55 years.
Huh.
Sometime born India 1942.
Father,
Father.
Father.
So father's
Then
name
if he-
would have been there in 66.
42. Acha, I calculated and I found him to be born on, 52, yes, 52. He would have born in 52.
42.
42
Yes. 97 minus 55.
or 97.
Minus 55.
In 89 voters list, he is shown as 37. You see 89?
So nothing.
89, he is shown as 37.
Exactly logic now.
So he will be around 52 born.
Yes, that is what we are saying, logic is 42 born. Because the age is fluctuating in all the voting lists. And somewhere it has not changed at all.
Oh, in that case, he'll be 42. But calculating the age from 89 voters list, he'll be 52.
From 97, it is 42. So his name ought to have appeared with Kasim
In that
Malik.
case, yes, his name ought to have appeared.
Even if he's relying on new documents, it doesn't support his case in term launch. Because I mean, just
Because-
expect.
Uncle Motito, he has passed away in 73 around 40 years. right? So if he's 42 born or maybe 45 born, at least he will be 40 to 50 to 60 to 63 minutes voting to Reservation he will receive.
Into 89 voters list have to be 52.
89 voters list of
47 years deficit.
97 that has 55.
89, 99. বেশি দেখা হবে।
For this, you have to rely on Aziz clear logic. 2023 4 GLT 46.
2023,
4 GLT 246. Paragraph 14 logic, just 4 lines. We are constrained to observe that a mere claim by a suspected person by referring to a voters list, claiming a person getting to be his father is not a conclusive proof, and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that the person who is reflected in the voters list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable. Trying to say lack of other materials.
Lack of other materials.
Other linkage logic. Yeah, my solution here to the thanks.
resolved. Okay, close this then.
लेकिन ना है
I am not, one judgment regarding new documents, my lord,
New document.
new documents.
Please cite.
2001, 10 SCC 619,
you went to take out this judgment.
my lord.
You went to take out this
No,
judgment.
619. Name.
Name, my lord, State of Rajasthan versus TN Sahani and others.
Sahani.
Yes, my lord, Sahani and others.
In what context? What is the context of?
Context, my lord, new document can be considered at appellate stage also.
At the
At the appellate stage also.
appellate
Appellate
stage.
stage.
Are we an appellate court?
Because since there is a no appeal, appellate forum is there, so this court has the power. My lord. My lord. There is no appellate forum. Where will go, my lord? We'll come here.
Analogy.
My lord. So paragraph 4 is just pass a reason and just and reason decisions. It to be considered. So, Supreme Court also held it.
For that you do not cite judgments. You have order 41 rule 27
Yes,
of the CPC.
yes,
But that applies only to a civil proceedings.
yes.
You can.
Court of one rule 27. What of done rule 27?
That is the law.
Yes.
And that also
But-
you cannot give as a matter of routine.
But
You have to show that in spite of due diligence, you could not have, you did not adduce the evidence before the
Yes.
trial court. लिखा जी अमित तो बाकी लग सब लिखी बात
একটা question দিবা।
judgment reserve को भी
Hello.
okay 2 o'clock we have some that matrimonial case I think not matrimonial child case and then thereafter let us see if it's possible we'll try to take one more case. Madam sister has a single bench.
Wait, your lordship. Lordship, can you take up?
Mr. Deka, one thing, on the last occasion, your colleague had said that he's withdrawing wakalatnama. Your
No,
petitioner will appear in person.
He's
Then
not-
today another wakalatnama. What is this going on?
No, that.
We don't recognize Mr. Deka or Mr. Sahiwala. We recognize the council. If you are representing, you represent. We don't mind somebody appearing in person. But not this kind of jumping here and there.
I'm not appearing in the contempt case, lordship. I'm appearing.
Contempt case is listed today.
No, the IA, lordship.
IA
Item number
for?
9. Item number 9, lordship.
No, 9 is which? We are in the contempt case.
No, lordship, I have filed additional affidavit with regard to item number 9. No, lordship, may kindly take up the IA which I have filed in item number 9.
IA in which? Disposal of writ petition.
Yes, lordship.
What is your IA for?
Yes. Lordship, it's a modification of an order passed by this honorable court, lordship. Lordship, the order, there has been a matrimonial dispute, lordship.
Now, what do you seek? What modification do you seek?
My lord, in lordship, may take up the order which was passed earlier.
No, first show us the law that in a disposal of matter, we can still have the jurisdiction to, unless it's a review application.
Lordship, it has been directed by this honorable court only. Lordship, may kindly.
In the
take up-
contempt case.
Yes, lordship.
What is that? We have
Lordship.
read, where is that order?
In page number, it starts from page number 30, 130,
130.
130.
130.
And the operative part, lordship. Paragraph 8, lordship. Page number 133.
133, yes.
In
Paragraph
lordship,
8.
8. Before coming to that, I'll just say in the earlier order, I was given only telephonic exchange, telephonic access Tuesday and Tuesday and Friday.
Now, what is the modification you want?
Now, Lordship, Tuesday and Friday, Lordship, it is not possible because she is studying in Mussoorie International School. Now, Tuesday and Friday are working days and she is not allowed phone, mobile phone. That can happen only on Sunday.
Sunday, okay.
Now, Lordship, what has happened, Lordship? She is on vacation. The vacation has started from 3rd. And I have not seen my child for last 3 years. And I do not have telephonic exchange, telephonic access for last 1.5 years because of that Tuesday and Friday thing. Now, all I want, Lordship, now since vacation is going on, and if we count it from today, I will only have 7 days. Lordship, in that 7 days, I wanted to have physical access to my
That
child.
we have already said that we are not entering into that field
No,
in the
Lordship,
order.
only
We have already, we have granted you telephonic access, and if you see the order, if you read the order, we envisage this kind of a situation. If there is some alteration, you can mutually agree to. If Sundays are there, for physical thing, you can approach the appropriate court.
no, Lordship,
The order by which we have disposed of the writ petition
Lordship.
wide on 8 to 2024.
Yes, Lordship.
Kindly take us to 8 to 2024.
Yes, Lordship. That Lordship would find page number 128.
See, this is purpose of this habeas corpus has been served. The child, for all other remedies, we are not saying that your grievance has come to an end. You may have all the grievance, but there are forum to raise the grievance.
Yes.
Not by way of a IA in a habeas corpus petition.
May I just
But
submit?
for that telephonic thing, we are
Yes.
agreeable. We can
May
let us have that look at it 8 to 24. Page
128, Lordship.
128. If you remember correctly, we had said something.
The judgment starts from page number 127.
Yes.
And Lordship, I'll read from para number 4. In page number 128.
Yes.
By the IA, the petitioner applicant has filed for an appropriate order directing the respondent number 7 to facilitate return and uninterrupted physical and
Let's say
telephonic.
come to 6. Let us come to 6. However, on
On
considering the prayer,
made in the IA, this court is of the opinion that the telephonic access of the applicant mother is required, taking into consideration the welfare of the minor child, which is of paramount importance. In this regard, specific instructions have been sought for from the learned counsel, and as per the same, the applicant mother would be allowed to have telephonic access to the minor daughter twice a week, namely Tuesday and Friday between 6 p.m. to 7 p.m. However, it is made clear
Yes.
that there may be slight modification in the date or timing subject to the convenience of the parties.
see, we envisage this, that there may be some difficulty. And
Lordship.
prior paragraph, at paragraph 5, we have said that habeas corpus matter is it has become functus officio because the child was produced.
Yes,
There is no scope to further entertain.
Lordship, may I just point out one thing, Lordship?
Yes.
Lordship, kindly see 133, what this honorable court has given the order. This in 15/9/2025 order. So, para number 8.
In contempt.
Yes, Lordship.
Yes.
In para number 8. In view of the fact that in para number 6 of the order dated so and so, the direction of this court was allowed telephonic access to the minor daughter twice a week, Tuesday and Friday between 6 p.m. to 7
That's
p.m.
where Mr. Deka, we have said we'll be allowing.
Yes, Lordship.
We will be allowing a time where you can have the telephonic access.
Lordship,
You are appearing for whom? The other side?
Respondents.
Respondent.
Response.
Perhaps you will not have any
Lordship, I
objection.
beg
if we
to
change the
appear.
time.
Mr. Fukan.
Mr. Fukan, you are there.
Hey,
Okay.
Milord, I am here. I'm sorry,
Yes.
Milord, I could not be there physically.
That
I'm
doesn't
actually
matter, doesn't
under some
matter.
medical exigency.
See, they are only seeking, they are seeking two things, but the other thing we have expressed our mind, we are not entering into. The thing which would be entertaining is regarding the changing of timings. In fact, we are already indicated in our order that it will be subject to partial modification, depending. Now, Mr. Deka is making a very categorical statement that Tuesdays and Thursdays is it? Fridays are, you do not have an access, and 1.5 years there is no telephonic access. That was not the purport of our order.
My Lord.
We give a timing which is convenient and which is timing which is actually, in actual terms, she'll have telephonic access. And there are allegations, counter allegations, we are not going into
Lordship,
that.
I'm not into this allegation thing, Lordship. I am,
You suggest a date,
If-
suggest a,
if Lordship, if I may just point out one thing, only one thing.
no, you suggest a time, date, the week of the day and time.
On Sunday, what time?
10:50 years.
Morning.
We allowed to use the rest.
Sunday, 10:30, she's saying.
We give 1 hour slot within that time. 10:30 to 11:30 or 10 to 11.
10:30 to 11:30.
Mr. Fukan,
Lordship, may I just?
I'll convey it to the client, my lord. If your lordship wants me to take instructions, I'll take instructions.
no, not required. There's, your client has to be informed. His consent is not there.
I'll
because
inform
It's
you.
only modifying the order. The order has already been passed after hearing both the sides.
So my lord is directing that for in the next Sunday,
Yes.
1 hour slot, my lord.
Every Sunday.
Well, the child actually is in school, in a boarding school in Mussoorie. So she'll be in with the father, my client, for a brief period, Miller. I don't know, 1 week or 2 week vacation. And for that, during that time, this Sunday will be workable. But for the school timings and all, Miller,
The school, Mr. Deka, you give us a suggestion. In the school, how is it possible?
Miller, the
There is
thing
a telephone in the
is also-
school?
School is not a party.
Yes,
And Miller, one thing I just wanted to point out before
She has
the
a
family
telephonic
court-
Yes, Lordship.
access in the school.
Yes, Lordship, she has.
Do you have the number of the?
Yes, Lordship.
You can give the number. We can state it in the order.
Yes, Lordship.
Miller, just one aspect, my lord, may kindly allow me to
Yes.
point out.
Yes.
Well, before the family court in Dibrugarh, they have already filed an application seeking custody and various other directions, my lord. So that is pending, repeatedly invoking the jurisdiction, my lord, of this honorable court.
No, it's not a. You see, we are not
In essence, a
entertaining.
habeas
We are not
corpus jurisdiction.
entertaining any application. We are only entertaining an application seeking change of time. So for an order which has already been passed by us, there is no
lord.
requirement of application of fresh mind or adjudication as such. We are only
My lord.
changing the dates and the times. Because 1.5 years, the statement has been made that there is no telephonic access.
That is
that
not
was the
correct, my
purpose.
lord.
May not be correct. May not be correct. But at least that is the
My
statement
lord,
made.
my lord, kindly give me 2 minute time. Just,
Why? What?
I wanted to make a point because she has been suffering a lot. I just wanted to,
Not on this forum.
I'm just coming to that, Lordship.
We are on the IA, Mr. Deka. We are not entertaining any other things. We are
Exactly.
not hearing anything else.
My lord, what has happened?
Mr. Deka, we are not hearing you on any other things.
The-
You have applied for change of timings. We have said that we'll change the timings.
my-
Now we are not entertaining anything else. You argue on the contempt case, we'll do it.
what has happened in the contempt case also, Lordship. But the thing is that this
Now,
person.
can we pass any other orders, Mr. Deka, in this IA?
No. I'm
Then
not
why
saying
are you
that.
wasting your time?
No, on the contempt itself, what I'm trying to say, Lordship, this person has arrest warrants in his name. Now, the thing is that the practical, I'm just pointing out what is the
Mr.
practical
Deka,
thing.
we will adjudicate in the appropriate moment when
Yes,
that
Yes,
when
Lordship.
that list is before us. That
Yes.
list is not before us.
Yes.
We are adjudicating an IA whereby you are seeking a change of times which we are already considered and in your
And
favor.
My only, I have not met I understand the legal, I have not been able to.
And you are in public law.
Yes, Lordship.
This
but-
is not an appeal or something matrimonial thing.
This-
You are in
this
public law.
lady, Lordship, for
226.
3 years, she has not met her daughter. And now it's a break and the custody is with him because of the school break.
So, Mr. Deka,
Only
can you
1 day
approach a
is-
writ court for a matter of this nature?
I understand. What has
You
happened?
come up in appeal, we'll do it.
No, Lordship. They have filed a custody case. What has happened? The miscustody case that my friend is referring to was filed by them, not by us. Now we are appearing in that case and we have filed out.
Are we looking into the custody case?
No, Lordship. Only my
Okay,
visitation.
okay. No, you appropriate at the moment you argue. Sunday, what, 10:30 to 11:30? And you give the telephone number, madam.
Lordship.
Give it to our court master in writing.
Lordship.
And till when are the vacations, Mr. Fukan?
Till 18th.
Till 18th. So this how many Sundays will be there till 18th?
Only one Sunday. If only one Sunday. So if possible, once I'll just meet her. That's all.
That we cannot. That was not the purport of the order. For meeting, you have to file the application before the appropriate authority.
Which
Which
is
you have
pending,
done.
my lord.
Not by us.
Lordship, am I allowed to withdraw submission?
We hear either you or your lawyer.
Now tell me what you want to say.
Contempt case में मैं ये नहीं कर दूँगी. Contempt case में. 45th में क्योंकि लोग appeal भी किए।
For custody, there are laws, you can invoke those laws. And ultimately, if you come to the High Court, we are there to hear you, not in a very petition. Please give the phone numbers. And
Sure,
yes,
sure.
next Wednesday, next Sunday, what do you do?
Next Sunday. Just see the date, na, next Sunday.
Today is 10th, Sunday will be 14th.
Sunday will be 14th.
Lordship.
Only
14th.
one Sunday that we will
So
get.
14th, how do you get access? In whose phone number?
Daughter's phone number.
She has a phone number.
Yes, Lordship.
Okay, Mr. Fukan, you facilitate next Sunday.
I'll communicate it to the
Okay,
client.
there should not be any default on your part. There's already some allegation. We do not know whether those are
Lordship,
in
if
the,
a video
it's-
No, no, the entire picture has not been brought.
no, no, it's in
before
the
Lordship.
realm of allegation. We are not saying anything, but allegation has been made that
Lordship, if
you have not
video
even
call-
All the
charged.
criminal
if video call
cases,
is
my lord,
possible,
my
please, Lordship.
instructions are,
Video call is possible.
Lordship, it's 3 years. I have not seen my child. Lordship, please,
Ah.
Lordship.
Okay. Heard 3 P. Deca Learned Counsel for the applicant. Also heard 3 A. Fukan Learned Counsel for the respondent number 7, who has appeared online. 3 P. Sharma Learned State Counsel is present for the state. Put up. There. By the instant application, comma, please have your seat. Have your seat. By the instant application, comma, the applicant is seeking a modification in the order dated 8/2/2024, passed in WP criminal number 27 of 2023. Full stop. Such modification is sought in view of certain observations made by a coordinate bench on 15/9/2025 in the connected contempt case number 249 of 2025. Full stop. Para. By the order dated 8/2/2024, both the writ petition, where is that order? 8/2,
Lordship, 121.
120,
That 8-2, Lordship.
8/2,
128.
121.
8/2 is 127. By the order dated 8/2/2024, comma, both both the writ petition and the connected IA. What was the IA number? IA
1012, 1012,
IA 1012,
which was disposed of.
1012, 2023 were disposed of. Full stop. For ready reference, comma, the portion of the order for which modification is sought for is extracted herein below. Para 6 to 40. 3 Deca, the learned counsel for the applicant has submitted that though this court had allowed telephonic access of the applicant to the minor daughter twice a week, namely Tuesdays and Fridays, between 6 p.m. to 7 p.m., comma, the daughter is studying in a boarding school where such telephonic access,
Mussoorie International School.
boarding name bracket Mussoorie International, where telephonic access on those dates are not possible. Correct? He has accordingly submitted that there may be a modification in the days and times so far as the said direction is concerned. Full stop. He has suggested that Sunday from 10:30 to 11:30 would be a convenient time.
10:30 a.m.
AM. 10:30 a.m. to 11:30 a.m. would be a convenient time. Para 3 Sri Fukan Dilan.
If WhatsApp video call.
Huh?
Video call.
Okay. Sri Fukan, the learned counsel for the respondent number 1 has submitted that on principle, though he would not have any objection to the prayer made, comma, there are many other developments in the meantime which developments in the meantime, which, puts the para. We are of the opinion, and after hearing the learned counsel for the parties, we are of the opinion that though the court becomes functus officio after disposal of the writ petition, there is an order passed by a coordinate bench to seek modification. We are also of the view that the modification sought for would not change the nature and character of the order passed by us. Tara, in view of the above, and as consented by the learned counsel for the parties, the telephonic access be allowed to the applicant to the minor daughter on every Sundays between 10:30 a.m. to 11:30 a.m. The
Lord, may I-
parties
Sorry.
may also explore on the option of having audio WhatsApp communication.
Video.
Video WhatsApp communication.
Your Lordship,
Since
Lordship,
since the child is in the school, the number, she'll have her own number, no?
Yes, Lordship.
Then we will not.
Number, we will provide a number. Lordship, and I have filed an additional affidavit. Lordship may at least reflect that so that we can go and approach that court with regard to that.
But it is made clear that for any other remedies, the parties would be at liberty to approach the appropriate forum.
Your
Mr.
Lordship,
Fukan,
just
anything?
one aspect. I'm sorry,
Yes.
Milord.
Yes.
If you dictated the order, just one aspect, Milord. When the child is in school, she gets 1 hour to interact with the parents, Milord. So if 1 hour is completely given to her, then
Not 1 hour. We have not said giving 1 hour slot. Within that slot, it may be for 5 minutes, 10 minutes. We're not
Yes,
saying
no.
the telephone will be for 1 hour. Within
no,
that
just-
period.
Just one more aspect, the child herself is a little reluctant now to communicate with her because of some issues
It
that
will be conveyed to the mother by her directly. It will be conveyed to her mother by her directly.
Yes, Lordship.
because I can't really force her if she doesn't want to communicate. That's all that
No,
I'm
she'll
saying.
be in school. You need not force her. You need not coax her. If she's
Right.
not willing, she'll say,
No,
"Then
that
I
is
don't-"
not the pleaded case. That is not the pleaded case.
I have not pleaded
So
anything.
what has
I have
happened to
not
the
filed any
mediation?
reply.
It has failed, Lordship.
Failed. Okay.
He didn't appear, Lordship.
I still dispose of her. Please
Obliged.
give the number.
Yes,
Okay.
yes.
Sure, Lordship.
Highly obliged.
But let us make it clear. Since we also make it clear that since presently the child is enjoying her vacation with the opposite party, on the coming Sunday, the opposite party will felicitate such telephonic access. And for those days when the child is in the school, the access will be done in the phone number of the child, which is mentioned in this order.
Yes, Lordship.
Highly obliged.
Highly obliged,
Highly
Totally
obliged.
obliged.
Analogous matter disseminate ऐसे हो
So we
सकता
could
है।
go on.
यही है law court वही है।
Number two, Lolo, What of my more type to Moria to go We'll have those series. There was one issue regarding that refugee thing. Where is Mr. Payang? We also wanted to have his assistance. He can come by the meantime, we can hear them. Okay. And you are also equipped with the instructions, I think. You are also equipped with the instructions.
May I, Lordship, I know something. Lordship, before starting the series, my lord, there is another item, item number 13, my lord, order matter, my lord.
Order for?
Order matter is actually, my lord, what happened, my lord? There is an interim order, my lord. But my lord, what happened, when we went to the SP border, my lord, they informed us that the already requirement as per the other district, my lord. So, my lord, that may be complete as a party, my lord, and my lord, my interim may extend, my lord. Only that part.
Let's see. We'll just finish this order.
My lord.
But madam, you have a look at this. Prayers looks very unequal, but there are so many things inside. So you have to look into it. So what is the matter, Mr. Hassan?
Well, I am 13, my lord.
1-3.
কিন্তু যদি রেকর্ড তিনি রেকর্ড আছে he could have said for a modification of the order কিন্তু to say from party bonds.
বেলেগ ডিস্ট্রিক্টত আমি
Mr. Hassan, which page?
Yes.
Lordship may first take up the IA number 162, my lord. Oh, sorry, my lord, 1862.
62. Page?
This will impugn order on page 10, my lord.
Yeah, maybe.
And 11th portion is page 12, my lord, para number 9, my lord. It was directed that we have to appear within 3/6/2026, my lord. And accordingly, 26 on the 26th May, my lord, we appeared before the SP border, my lord, of Borpata district, my
Yeah,
lord.
thereafter,
Then, my lord, they informed that the already record already been transferred to the Buxa district, my lord. So, my lord, they advise us to submit this order before the Buxa district, but then the order is specifically directed that only to the Borpata. district.
initially, it was the border.
Yes, my lord, by the Borpata.
Borpeta. Okay,
Ma'am.
we can allow this, mister? Yes. Okay. And the, what is the other eye?
Other only extension of this order, my lord.
Okay. Both the eyes being connected are taken up together and are being disposed of by this common order. Tara?
কিন্তু prayer to don't to implead. No, it will implead 16862.
Or extension of term.
It will extension. কিন্তু implead to do that. Oh, he to implead.
The eyes are filed in connection with an order dated, connection with WPC, so and so, and the order dated 22/5/2026 passed in the said writ petition, full stop. By the aforesaid order, comma, while notice was issued, comma, the petitioner was granted bail subject to certain condition, including a condition for appearing before the Superintendent of Police, Border, Borpeta, on or before 3/6/2026. Full stop. Para. No, it is in the context of the aforesaid condition that both the IAs have been filed. Full stop. While I number 1862 has been 61 has been filed for
Extension.
for modification.
Yes,
1861 is for modification of the said order, comma, I 1862 of 2026 has been filed for impleading the impleading party respond numbers, impleading the district commissioner Baksa, Mosalpur, and Superintendent of Police, Border, Baksa, as respondent numbers 8 and 9, correct?
Ma'am.
Sir, we have heard Sri K.M. Hassan, learned counsel for the applicant. We have also heard so and so. Sir, Sri Hassan, the learned counsel for the applicant, has submitted that that in compliance with the order dated 22/5/2026, comma, the applicant had appeared before the Superintendent of Police, Border, Borpeta, on 26/5/2026, which was within the stipulated period, which was up to 3/6/2026. Full stop. However, on such appearance, comma, she or he was informed that the records have been transmitted to the Baksa district. Full stop. He has submitted that in view of the above, both the relief, the applicant is constrained to file the present IAs seeking appropriate relief. Full stop. Tara? Sri J. Payang, learned standing counsel, Home Department, has not raised serious objection to the aforesaid prayers, full stop. A similar stand has been taken by the learned counsel for the other respondents. Para? In view of the above, comma, both the IA stands allowed, full stop. The order dated 22/5/2026 stands modified to the extent that the observations made in paragraph 9 would pertain to a direction for the petitioner to appear before the superintendent of police, Baksa, border Baksa, on or before 19th,
My lord, 19.
19th. You have more than 10 days. You'll get the certified copy today itself. 19th, 19th, and 19th, and the conditions imposed in the aforesaid order would prevail. Full stop. It is also the petitioner is also allowed to implead the following incumbents as respond numbers 8 and 9. Incumbents করে বেলেগ বেলেগ করে লিখবা একদম এনেকে এনেকে আমার জনকে লেখা এরো পার্টিস প্রথমত ডিস্ট্রিক্ট জনকে 8 8 তারপর 9 full stop. Petitioner, the learned counsel for the applicant is accordingly required to file amended cause title in the amended cause in the writ petition.
My lord.
Both the IS students disposed of. উপরতো যদি লেখা সেটা ইমপ্লিমেন্ট তলত আমি এটা লাইন লিখি দিম এজ ইন্ডিকেটেড এবাউট বুলি এটা লাইনত নেথাকিবা কিন্তু এনেকে নেকি ইয়েস সিরিজ
Item 19 to 27.
May I please, my lord, in this present case, my lord, there is basically, my lord, two issues, my lord. One is larger issue, my lord, and one issue is pertaining to this present case, my lord. The larger issue is that, my lord, registration certificate issued in the year 1996.
No, let us since all the cases are connected
Yes, my lord, all this.
because of the larger issue.
Larger.
Let us
Let
try
us
to
first issue
resolve
the
the larger
case
issue.
issue pertaining to this case, my lord.
Okay.
Start first, my lord. In this case, my lord, what happened, my lord, that initially, my lord, reference was made against the only the petitioner, my lord. In this reference, my lord, the name of
You,
the
Mr.
petitioner,
Hassan, you are for which case?
first item 19, my lord.
Number, number?
Item number 19, so 7071, my lord, 2019.
707119, okay. There was a reference.
Yes, my lord. The reference only against the petitioner, my lord. However, my lord, in this reference, the name of the petitioner's wife and his daughter names also written as the family members and the spouse name, my lord. What happened, my lord? The learned tribunal, going beyond its jurisdiction, my lord, issue notice against the all three person. Present petitioner,
Issued notices.
yes, my lord, against his wife and his daughter also, my lord. But during trial, my lord, the petitioner submitted his written statement, my lord. After that, my lord, the trial is began, my lord. During trial, my lord, the wife of the petitioner deposed before the tribunal as DW1, my lord, and she deposed and she exhibited only the documents which were pertaining to her, my lord. And subsequent that, my lord, the petitioners also deposed before the tribunal as the DW2, my lord. That is the main problem, my lord. Where the problem is, yes, my lord. Where the problem is start, my lord. What happened, my lord? There is no sheep, no cross, only a evidence which was recorded under section 165 of the Indian Evidence Act, my lord. Only that is a one page as an evidence, my lord, which is recorded by the.
That is not chief.
There is no sheep,
No,
no
that
cross.
evidence.
Only 165, my lord. That is taken, my lord.
By the court.
By the court, my lord.
No, court can seek clarification, can
Yes,
put
yes,
questions
my lord.
to
Yes,
bring
my
out the truth.
Yes, my lord.
But evidence as such was not adduced.
No, my lord.
It is only by exercise of powers under 165.
My lord, my lord. That is my lord, only humble prayer before leadership. As my lord, there is the no sheep, my lord. So, my lord, I could not.
No, but you said wife had adduced evidence at DW1.
My lord, she exhibited, her part is clear, my lord. She deposed before the table as sheep, and there is also some cross. Also, cross means, my lord, there is also maybe my learned tribunal put some questions, my lord. But in her evidence, my lord, there is a sheep, my lord. But my lord, while the learned court below, my lord, when they passed the judgment, my lord, she only passed the judgment against the pertaining to the present petition also. When at that time, my lord, the Honorable High Court already settled the law where there is no reference, there cannot be a judgment against the other party, my lord. So, my lord, the judgment rendered against the only the present petitioner, my lord. So, my lord, this part, my lord, never taken into account, my lord, in this judgment, my lord. Only, my lord, discuss about the my part. But, my lord, my only submission is that, my lord, I have never deposited a sheet, my lord. Only the questions put by the learned tribunal under section 165 of the Indian Evidence
But
Act.
what prevented you from giving your evidence?
My lord, I went before the tribunal, my lord. Even 2-3 occasions, well, though there is several occasions, they took time also, my lord. But present petitioner was present, my lord. The learned tribunal did not take evidence, my lord, chief, my lord, recorded chief, my lord.
So you have to file your evidence in by way of an affidavit.
My lord, but my lord, at that time, my lord,
If you
all
do not
cases-
file your affidavit,
my lord,
where will be the cross-examination?
my lord, but my lord, in this, and usually, my lord, what happened, my lord, there is 2 ways taken in earlier, my lord. Presently, all
No,
are,
Mr. Hassan, so far as the first argument is concerned,
my lord.
we rest assured that you cannot, the law is settled
Right.
unless there is a reference specifically against a particular individual.
Yes, my lord.
No opinion can be rendered.
My lord.
That is there, but you have not adduced evidence on your own volition.
But I went for the evidence, my lord. When the learned tribunal did not allow,
Where have you stated that you have gone for? How do you go for an evidence?
my lord,
With an affidavit in chief.
my lord, it may not be mandatory that we have to file the evidence in by way of written evidence, my lord. It can be oral, my lord.
After in today's context, there will be oral evidence in chief
I mean, there is also some tribunal there. is
in
oral-
civil matters.
No, civil matters not, my lord.
Then
But my lord, tribunal took,
it's
my lord,
not possible to have chief
this-
examination by way of oral evidence
in these cases.
after the amendment. It has to be in chief. It has to be by way of an affidavit.
My lord. But my lord,
Had
at
it
that
been an
time-
old case,
My-
very old case, that would have been different. Where is your statement that you had gone to adduce evidence?
well, that is will not be written.
Then
But my lord, petitioner was present, my lord. Only, my lord, my
that will not do.
lordship once may come to, my lord, my evidence part, my lord. Yes, once may come. Lordship may, this is my lord.
We'll decide
case-
on the
case-
basis of
case
the
59.
evidence adduced in accordance with law. DW1 was there. We'll examine DW1.
My lord, DW1 only part, only she examined only hard part, my lord. She exhibited only hard documents, my lord. Even my lord, though my lord, there is in judgment, my lord, it was quoted that I exhibited some documents, my lord. Even my lord, this evidence also, it is, I could not file, my lord, how I can exhibit some documents, my lord. How these documents are coming to the record, my lord. This is not been mentioned, my lord.
Payam, what is your, have you understood the issue?
Yes.
How do you react to this?
First of all, my lord, it is admitted position, proceeded received notice.
He's contested
Contested. It is his fault, my lord, he did not depose. And his wife.
and there is no statement that he had gone to adduce evidence. Even if we assume that there is still the practice of having the chief examination orally, there has to be a statement that I was present on such and such date with my evidence ready to stand in the witness box. There is no such statement.
Yes, submitted written statement. Social Mishra submitted written statement.
There, see, to put in a very simple manner, there is a written statement, there is an evidence. Who is given the evidence, we are not too much concerned with now.
Yes.
We'll decide on the basis of the evidence.
Question put to DW2. He was questioned by the
Tribunal.
tribunal. That means he was there. He had the opportunity to give his evidence.
Yes, my lord. That is my.
He had the chance to give his evidence.
My- When my lord, learned tribunal when put question to me, that means when I was there, present at that time. Without taking seat, my lord.
Mr. Hassan, we would rather perceive this in a very different manner. It was benevolent on the part of the tribunal to put questions to you because you did not adduce any evidence. It was for your own benefit. That now we are giving you a chance. Tell something.
Yes. Despite of not giving evidence.
You cannot say this is to your disadvantage. 165
lord.
examination is for your advantage.
Well,
Because
I
you have not
admit
said
that is
anything,
my-
please say something and discharge your burden, which you have not done.
My lord.
Your projection is not correct projection, unfortunately. And this is not an issue which requires a great kind of determination. We are something that
Maybe,
refuse the certificate, something we are on that.
My
There's
lord,
nothing to be decided here.
I may be wrong, my lord, but my lord, what happened, my lord, when there is no seat, my lord, then cannot be a question may be put under.
You cannot put this submission in this manner when there is no chief. What precluded you from giving a examination in chief?
My lord, when.
Where is the statement that you, in spite of, you cannot support this. Unless you support this, we cannot take this into cognizance.
But my lord, only my submission is that, my lord, the entire trial is not properly conducted, not proceeded as per the law, my
That
lord.
is a general phenomenon. Everybody is complaining that
But my lord,
the
even-
conducting council did not.
No, my lord, no, but I'm not in the conducting council. I'm telling about the member of the land tribunal, my lord. And my lord, even I go through the record, there is also mentioned a miscase, my lord. That is also not available in the record, my lord.
What observation has been made by the landed tribunal, Mr. Payang, on this regard?
With regard to my lord,
And Mr. Locher, what is your case? Same, similar.
In my next case, my lord, there is no reference against me, my lord. Reference is someone else, my lord. In the name of someone else, my lord.
This matter, each and every case have to be named.
But
So
the
why is
issue,
it-
common issue is, my lord, refugee certificate in all the cases.
My registration.
Refugee
Registration,
certificate will
registration.
will decide on merits of each case, but unless there is a reference, opinion cannot be given against you.
That's why, my lord, then in that case, each and every case has to be seen separate.
But how do you say that the reference is not against you?
My lord, if we see the reference, my lord, the reference is against one Horen Mondal, my lord. And I am is my lord Nivaran Bishwas.
Someone.
My lord, verification officer after inquiry, my lord, submitted report, my lord, in the name of Horen Mondal. Notice was issued, my lord, Horen Mondal. Subsequently, learned tribunal find that Horen Mondal is my father and I should be the proceeding. Then he, without any, my lord, issue notice, my lord, to me.
That is wrong, my lord, that cannot be done.
That we can take care of. Other cases,
Then here is also, my lord, the same case, my lord, the registration certificate, my lord.
no, that case we can interfere by saying that unless there is a reference.
And another aspect, my lord,
No, we cannot allow your repetition twice. We'll allow once. So you need not plead any further grounds. You want a double, two orders allowed twice.
my lord, then, my
What
lord,
are the other cases?
That
my lord, next,
repetition-
my lord,
It took 6
here, my lord, this,
Many cases are there.
my lord, I think 6 or 7. Next, my lord,
Hassan is in 7071.
My
And which one?
only that.
the
and-
only,
Locker,
my lord, the Nivaran Bishwas, 6484 of 2007.
6484.
This is the, my lord, leading case, my lord, where tribunal took this reference of this case, my lord, in all the judgment, my lord, in all the opinion, my lord. Nivaran Bishwas.
Nibaran Biswas, the reference was in respect of the father.
name.
Horrendo Bishwas. And now, my lord, next item, my lord.
Horrendra Biswas.
Yes, my lord, Horen Bishwas.
Horen Biswas.
Horen Bishwas.
Was he alive?
No, my lord.
He wasn't alive.
Then, my lord, next repetition, my lord. 340. These are next brother of Nivaran Bishwas, my lord. Ukil Bishwas.
Ukil.
Ukil. I think, my lord, his name is actually, my lord, Ukil.
No, the Ukil can be a name. If contractor can be a surname, why not Ukil can be a name?
Yes, my lord. Here, in this case, my lord, reference was issued.
Engineer can be a surname.
Hmm.
Contractor can be a surname. The famous cricket players.
But he could be the, my lord, local in that area.
Maybe. Without a law degree.
Yes.
3410,
Yes, my lord.
Ukil.
Ukil.
That is in respect of?
This is my lord, this,
Same.
no,
Same.
brother of Nivaran
No,
Bishwas.
same
my lord.
analogy.
Same analogy.
Without there being a reference.
Yes, no, my lord, here, my lord, reference is there against the Ukil Bishwas.
Then
But so far the other petitioner is concerned, there is no reference.
How many petitions?
Three petitioner, my lord. Total four petitioner, my lord. Only one is the reference is against only one. Ukil
So
petition.
we can adjudicate so far as the reference against Ukil is concerned on merits.
Yes,
So for the others are concerned, we can straight away say that this will be outside the purview of
my
Mr.
lord,
reference.
my lord.
But we can adjudicate for Ukil.
Yes, my lord. Yes.
If you are ready with it, and what, and one more case, what are the other cases?
Other cases, my lord. Here in this case, my lord, there is some discuss. 3940.
3940 of?
Same, my lord, the registration certificate.
No, of 2017.
2018, my lord.
Yes, name?
Name, my lord, Radhesham Nath.
And three others.
Three others, my lord.
And three others, same issue.
My lord, reference is only against Radhesham Nath. There is no reference against other petitioner, my lord.
Those are the wife, children or something?
Yes, my lord, the family.
Reference. Radhesham. Yeah, okay. And 1, 2, 3, 4 cases and
Then again, my lord.
4246. এটা এটা আমার। মিঠুন মণ্ডল।
In every cases, my lord, something, my lord, issue is slightly different, my lord.
so
In some cases, my lord,
why are these cases taken
the main larger issue is, my lord, the registration certificate. In some cases, my lord, earlier they were declared Indian, my lord. Now, my lord,
argue on merits? So far as the opinion against persons who are not parties to the reference, we can we have been passing orders. But
yes,
so far as the main person is concerned,
yes, my lord.
will adjudicate on merits?
Yes, my lord.
Okay. Yes, please. It is good. One other cannot do. Yes, which one will you argue first?
My lord, this Nivaran বিশ্বাস.
So far as Mr. Hassan is concerned, 7071, what will happen? This will not be
But my lord, there is the judgment of this coordinate bench, my lord.
That-
This is settle this issue and revert back the petition up to the tribunal, my lord.
let us see. Then we'll decide Mr. Hassan.
My lord, my lord.
ট্রেনটা তো ইন্ডিভিজুয়াল বহুত দিন হয়ে যাবে।
Individually করে বলবো, ওখানে।
কিন্তু কি হবে না?
আজ না হয়, তাহলে কি করবো? তুমি যেটা বলছো।
এটা কম হবে। ট্রাইডেন্টটা উঠালে ভালো ছিল।
Okay, after this case, probably we may not have time.
My lord.
Okay. But we will have this in these days only.
My lord, relevant para is page 6, my lord, para 12, my lord. Para 12 to
What is your case today? What is your number? Sachin Biswas.
707 or Sachin Biswas. My lord, another thing, my lord. Sachin Biswas, Radhesham Biswas, they are all Nivaran Biswas, all are brother, my lord. Same
Ukil
thing.
বিশ্বাস, Nivaran
But
বিশ্বাস.
they had reduced evidence.
My lord, yes, my lord. But in my
You did not reduce evidence.
But I went to depose before the tribunal, my lord. Tribunal,
How your brothers could have given evidence?
my lord, actually, my lord, what happened? They already exhibited the documents before the tribunal, my lord. The tribunal already been acknowledged the everything, my lord.
No, what about their evidence on affidavit?
Let at the relevant time, my lord,
Deposition, not the document, the deposition.
I admit, at the relevant point of time, all are usually, my lord, tribunals are taken the oral evidence, my lord. At the
Their oral evidence was taken.
but in these cases, my lord,
No, Mr. Dhakur, what about your deposition?
oral evidence, my lord? Oral evidence, my lord.
Was it taken?
Yes, my lord.
Taken?
Oral evidence, my lord.
They were there.
So, my lord, when the Lanet tribunal did not take my oral evidence, my lord, I have to
Let
nothing
us
to
see
do.
which paragraph.
My lord, page 6, my lord, para 12, my lord. May I, my lord? The examination in chief of the DW2 having been made by the learned tribunal in the fifth instance of non-application of the mind by the learned tribunal because under section 137 of the Indian Evidence Act 1972, it is for the party produce the witness to do the examine in the chief because under section 9 of the Foreign Act 1952, the burden is on the proceeding to prove that she is a citizen of India. The Foreign Tribunal Order 1964 does not provide that the tribunal would conduct the examination in chief of the witness produced by the proceeding defense. With the oral examination of the witness of the defense by the learned tribunal had failed to consider that if it was examined the defense witness, that is the DW1 and the DW2, would such examination be an examination in chief as envisaged under section 137 of the Evidence Act 1872. Then, my lord, 137 is quoted, my lord. Thus, on the plain and the simple readings of the provision of the section 137 of the Evidence Act.
Mr. What you said?
Your Lord's this record from the record, order dated 3/4/2017.
What is this?
Yes. By order dated 18/12/2016, the last sums was recorded to the opposite parties to adduce their evidence, fixing 10/1/2017. And on 10/1/2017, they had filed an adjournment petition contending that due to sudden illness of OP number 2, it is the petitioner, could not appear before for adducing evidence at prayer for another day. Accordingly, the tribunal allowed fixing 16/3/2017. On 16/3/2017, the OP had filed another petition being number so and so, contending that due to death of close relative of the learned counsel for the office, OPs could not remain present and as such prayed for death. Accordingly, OPs were given sons on 3/4/2017. Today also, they have filed a petition being number so and so, contending that they have engaged a new lawyer and as such seek another day. The entire approach of OPs, as seen above, is simply a delay
Mandatory, yes.
Yes, affect the proceeding of the court, and as such, the ground shown in the petition is not accepted. However, there is not. However, on perusal of the record, this tribunal has come across the photocopy of the citizenship registration certificate that issued in the year 1961 to one Sri Farindra Biswas.
Mr. Hassan, something else is there in the record.
Yes.
My lord.
Numerous chances were given.
My lord, I admit, my lord, numerous chances were given.
You
My
are
lord.
saying that
Then, my lord, this issue arise, my lord. Now, my lord, he involved in the same other dealing is the issue that whether this is acceptable or not. Then he issue notice to the deputy commissioner, district collector, my lord. Then, my lord, this will be my lord.
But you had, in spite of numerous chances, you had failed to adduce evidence.
Yes, my lord.
Where is the fault of the tribunal? It cannot be an endless exercise. 60 days is the limit mandated by law.
My lord.
314.
It is not that, my lord, he was not allowed.
My lord.
No, you have not projected your case fairly, Mr. Hassan.
My lord.
You should have said there were circumstances for which I could not. You simply are making a statement that
No,
on the basis of 165, it has proceeded. That is not the correct position.
my lord.
My lord, the
Apologize.
tribunal is genius enough, my lord, they have allowed him under 165 days.
Numerous dates.
My lord, initially, my lord, there are several dates were given, my lord, and it took several adjournment also, my lord. But, my lord, this tribunal never may.
That this citizenship certificate was submitted in some other case, original. That issue has came. Then the EC replied that.
And Mr. Hassan, even if you are thinking of giving you a chance, there are no pleadings that you are prevented or you are not allowed to adduce evidence. Show us the pleadings. And pleadings could not have been there in view of this categorical orders passed by the learned tribunal. One charge after the other. How can there be pleadings? I don't think you
My
deserve
lord,
any.
My lord,
Sympathy.
on that day, my lord, the case was fixed for the evidence, my lord. When I went there, my lord, that means I present before the court for the chief.
Or before that day, there are numerous dates.
Yes, I admit, my lord, that before that day, several dates were adjourned, my lord, and these issues raises, my lord. Then, my lord, give this date, my lord. On that day, I was present before the tribunal to adduce myself as a DW2, my lord. But the learned tribunal, without taking my chief, my lord, the learned tribunal put such questions, my lord.
Learned court cannot take the chief. It is for the party to
Yes,
take
my lord,
it.
I was there, my lord, to depose myself, my lord. But learned tribunal, when
You should file your affidavit.
By which order, Mr. Pang? The
3/4/2017.
last order, or what was the ultimate direction?
And the entire approach of APS and above. In the main, however, a pellucid of the record distributed by come across the photocopy of citizenship registration certificate and so and so, so and so, so and so.
That means he was not there for adducing any evidence. In spite of that, tribunal had seen the whatever materials were there.
And registration certificate is issued by various authorities in pending of the disposal of the series fixed on so and so. 19/4/17. The incident case is also fixed along with series on 19/4/2017. Go only for that issue, my lord, that certificate. In the meantime, OPs are directed to submit the original citizenship registration certificate on or before 19/4/2007.
এটা মানে অকলে oral oral evidence নয়। It is called the party to reduce evidence. Put an examination sheet ke upor.
On the merits of the challenge, what do you say?
Citizenship certificate, the sole basis is the citizenship certificate now. Now, the authenticity of the citizenship certificate would not be asserted from the deputy commissioner. That is admitted position. The deputy commissioner office says there is no record.
There is no record. Record is
They
not
could
traceable.
not be traced, my lord.
Could not be traceable.
Record could not be traced.
Pertaining to the year 1961, my lord, only.
So what will happen in those cases?
That means he had a citizenship certificate. It was not traced.
Record nahi. Again, authorization.
ADC has said, ADC, action office Nagaon said, reference to the subject cited above, I am employee here is letter received from so and so.
কিন্তু 165 courses are citizenship certificate আছে বলে।
Where is your 165?
Page 60, my lord, 60.
60?
Nine.
You have said, I don't know how, I don't know, but I claim myself to be an Indian citizen. You didn't speak about the citizenship certificate.
My lord, in as per this, my lord, question, that's, my lord, not in.
Then how will that issue come up for
My lord,
consideration?
that is the my lord problem, my lord. How, my lord, learned tribunal called for the record from the other cases, my lord, and it is also mentioned as the exhibit A, my lord. Exhibited as exhibit A. But in this evidence, my lord, he has no exhibited, no documents, my lord, but learned tribunal considers exhibit A, B, C. And exhibit E also, my lord, without my voter list, my lord. But there is no exhibit, my lord, in this my deposit. If lordship may peruse the order of, that is also the record, my lord.
He is such a mukha, he goes to the second. I remember that examination in chief probably until. The whole. এখানে কিছু টুকু কিছু 160 খানে একটু ভুল হয়েছে আগতে আমি হয়ে গেল
তোমার হাইকোর্ট বোর্ড হার্স সুশীল কি হবে এই যে তো কনসেপ্ট ভেরি হার্স
how is the judgment helping him?
No, not that. 11 to 6.
Before into non-application of 9 minutes.
I will put I will put it on the discussion by camera. And none of the English school very good. I think it's heavy evidence. You must have to
Yeah, no, I'm not for
fifth instance, the fifth instance, I make it.
Yeah,
15 cents indication.
non-application of time.
15 cents. It's a pretty one.
I do. You know, that's a fact. You do examination in chief logo no, I know. Party is in this group.
You are treated a fix. If you put questions, they'll say that you are putting questions. If you don't put question, it's like 1.65.
No.
If you put 165, cross question.
Because he will listen. Procedure is okay. Now merit of the side
We decide on the merits. No point. We are clear on the aspect after reading the orders of the land and tribunal.
Thereafter also he was given chance. Thereafter also he was given chance.
You have to adduce your evidence yourself by the party. You cannot wait for the court to. Court cannot take your examination in chief.
I admit, my lord, that part, my lord. But my lord, till then, my lord, when I was examined on the 25/9/2018, on that day also this case was fixed for evidence, my lord.
Yes.
It is not a part that this case was not fixed for the another for another aspect, my
I
lord.
would like to
This case was fixed for evidence, my lord.
from my learned friend, 25/2008. Opposite party number 1 is present, who has been examined as DW2 and discharged.
Yes, my lord.
Seen the petition filed by OP number 2, seeking time to adduce oral evidence of our brother of DW3 in the instant case. Prayer is allowed.
Even for
DW2 filed petition to seeking permission to file evidence on behalf of DW3. That was allowed. He has not said anything about himself. In the meanwhile, during cross-examination of OPW1 today on 25/9/2018, some relevant documents have been submitted by the OP, fixed further evidence on 12/10/2018. On 12/10/2000, OP party has appeared, further evidence is not necessary. So thereafter also, on that day also, he did not adduce. Thereafter also, he did not adduce.
He waited for the court to do everything.
Yes. That court did my lord 25.
Court did 165.
Court-
My lord, my
when
only,
there is no evidence to clarify himself,
Yes.
court can definitely examine.
Yes.
165.
my lord, my only submission is that, my lord, if I not examine myself, I'm not orally deposed before the tribunal. Tribunal ought not to have put this question to me, my lord.
Why not?
Why?
Rather, it's helping you.
165. You read 165 of the
Yeah.
Evidence Act.
And you cannot say 165 cannot be taken resort to unless.
At any time for some reasons, court may put question to me, my lord. That's it. But my lord, on that day, my lord, it was fixed for evidence, my lord. I went before the court. I appeared before the court to depose myself as a DW2, my lord. When this question was put, my view is that, my lord, the court taking chief, my lord. I am a layman, my lord. I could not know anything, my lord.
If the
Your
court,
advocate was there.
if the court takes chiefs, you come running to the high court.
Yes.
Court has taken chief.
No,
If the court takes cross, come running to the high court. Court has
No, my
taken
lord, no, my
cross.
lord. My lord, my apology, my lord.
No, that is okay. One can come. If
You
court takes.
have not done your duty. Your duty, not your duty, your obligation to adduce evidence. Numerous dates. In fact, your wife has given evidence.
I initially give, my lord, before that.
What prevented you? Where is the evidence of your wife? Let's see. Which page?
It start from page 57, my lord.
57.
Yes, my lord.
Who is Susan Biswas?
Or I am the
Sachin Biswas is my husband.
Susan, alias Susin. See, DW1 at page 57. Nicely given evidence, cross-examination, everything.
My lord.
You do it, I read. 57, if you read 57, this evidence is for her. Who, for her, means the wife. I have one vote of friend of my mother's name and my grandfather's name. She has not said anything regarding Susan because it was perhaps understood that each one has to define it himself or herself.
It's okay.
And there was this two, and she was an POC.
But then this tribunal has not gone against her. ওই অকল তখন সচিন apply করেছে।
Where is the
Agreement আছে আছে। मैं सालों भेजो। Only Sachin. Sachin Biswas. This case is only Sachin Biswas. And here she had given her evidence. But I could one, no. The wife of the petitioner had given her evidence in respect of this case or some other case?
This case. But initially the notice was issued in her name also.
Because see her statement, it is only in respect of herself. She has not said anything
Yes, my lord.
about her husband.
Only in respect confined to her only.
wife or name?
Gopa. Gopa Biswas. Jopesh na ki kora? Jopa. Jopa.
This opinion is common opinion.
No, my lord. Only against me, my lord.
What is page 50 then? Page 50, paragraph 7.
50.
Paragraph 7.
No, my lord. That is not related to my other case, my brother's case, my lord.
No, it will kill.
Opinion, my opinion is start from my lord, page
Kill and
63.
others.
No, sorry,
Page 63, my lord.
all as the other brothers, Akhil Biswas have been already declared. Is also declared opposite parties are illegal immigrants. I declared Akhil Biswas, Foreign Biswas, son of Foreign Biswas, Sikharane Biswas,
এইটো একেলগে দিছে।
Miss Tapasya Biswas, and Akash
And
Biswas.
son number 4, Akash Biswas.
My lord, impugn order is start from page 63, my lord. Page 63, my lord.
Sachin,
Where is your opinion?
63, my lord.
It will relate.
63. It was all Sachin. এইটো কেছ সিহঁতে কিয় নেক্সট কৰিছে উকিলৰ কেছটো
হয়।
ভায়েক ন উকিল and his family.
Look at page 64 of High Court judgment philosophy. They actually cannot pass orders against somebody who is not against whose reference is not. What is the 2017 2 GLT 974?
My lord, this is the, when there is the no reference, my lord, the.
Oh, that has already been taken into consideration.
My lord.
That's why, my lord, he,
My
wife
lord,
and brother,
brother already been
they have an example.
reference by, my lord, the impugnator only against me, my lord, not other person.
So you can argue, Mr. Sam.
Yes, my
What
lord.
are your documents? This.
My lord,
Who do you know it?
my lord, in this case, my lord, only which was exhibited my wife, my lord, only one document, my lord, exhibited total list of 2000, my lord. 2016, my lord, that is exhibited by my wife, my lord. My only submission is that, my lord, once my lord, matter may revert back, my lord, as my lord, I could not be examined, my lord. Even my lord, on that day, my lord, the case was fixed for the evidence, my lord. I appear before the tribunal, my lord. Even though the tribunal did not take my evidence, my lord, they only put some questions under section 165, my lord. On that day also, my lord, my wife submit a petition, my lord, that he will adduce the other evidence of her brother, my lord, to prove her case, my lord. Only, my lord, this is my submission, my lord. If lordship may, my lord, in respect of the judgment, my lord, of this honorable court or coordinate bench of this honorable court, my lord, which I before the lordship, my lord,
Let him adduce evidence.
in case of Ashok Ali, my lord.
Ashok Ali, which paragraph?
My lord, paragraph 12 to, my lord, paragraph 16, my lord.
What is there? Please read.
My lord, that is my lord.
What is the meaning of 12 to 15?
15, my lord.
Have you gone through, Mr. Take one copy. Or you read.
Read.
Yes.
In absence of 15, in absence of any provision under the Foreigners Tribunal Order 1964, it has to be presumed that
15
Yes,
years.
my lord. Is it start from 12, my lord?
12.
Well, the examination is of TW2 having been made by the learned tribunal in 55th instance of non-application of mine by the learned tribunal because under section 137 of the Evidence Act 1872, it is for the party to producing the evidence. The examination in chief because under section 9 of the Foreigners Act 1946, the burden is on the proceeding to prove that he is a citizen of India. The Foreigners Tribunal Order 1964 does not provide the tribunal to conduct the examination in chief of witness produced by the proceeding defense. With oral examination of witness of defense by the learned tribunal, the tribunal has failed to consider that this examination, if it was examining the defense witness, the detective would examine the examination in chief as and based under section 157 of the Evidence Act 1870. Then paragraph 14 does on plain and simple reading of the provision of section 137 has been said, appears that unless the party calling the witness examined the witness, it cannot be said that there was any examination in chief of the said witness. Hence, the corollary issue would be that if there is no examination chief, there cannot be any cross-examination. In absence of any provision under the Foreigners Tribunal Order 1968, it has to be presumed that the power of learned tribunals to question the is derived from 165 to Evidence Act 1872. If the tribunal has such question under section 165 to Evidence Act 1872, then without the leave of the state learned tribunal, neither the parties nor the agents, which includes advocates, shall be entitled to make any objection to any question or order. That's the only presumption that can drawn in this case is that the learned tribunal had exercised the power as to ask any question under section 165 the Evidence Act to a witness. Therefore, in this case, the learned tribunal having asked question to the witness of that is DW1 and DW2 created two distinct situations. In respect of DW1, having examined DW1 and then discharging him, the learned tribunal is found to have deprived the state of possibility to prosecute DW1 as thus evidence of DW1 remains undefeated. Insofar DW2 is concerned, having asked the question to this is not related.
How does it help you?
My lord, in
This
this
is
case,
not this is not for examination or cross-examination.
my lord,
This is directly said.
That is why we wanted to have the opinion of Mr. Hassan. How is it connected?
my lord, this is how it's connected, my lord. May I, my lord? But in this case also, my lord, there is initially there is a evidence on written evidence submitted by the DW1. The court somehow, my lord, did not take into consideration, my lord, then take the oral evidence of the DW1, my lord. Then there is no cross
Mr.
examination.
Hassan, what prima facie document do you have to show that you are a citizen of the country?
My lord, this is the exhibit E, my lord. This is the my voter list.
Huh?
Exhibit E.
E, page. Page.
My lord, page 61, my lord.
You are 45 years
Yes, my lord.
in 2016.
Yes, my lord.
So how does it make you a citizen?
No, I am the son of Horan Bishas, my lord.
No, and where is Horan Biswas?
My lord, there is in father's name, my lord, it is column number 5, my
No,
lord.
no, how do you connect your, where is the citizenship of Horan Biswas?
My lord, that is the citizenship certificate, my lord.
Where? Page?
Exhibit A.
And in 2016,
My lord, lot
you are
number
45
company,
years.
Page 18, my lord.
Where is your earlier voter list?
So, there is not been exhibited before the trial.
Then
tribunal, my lord.
45 years, till 45 you have not voted.
My lord.
Where is your case? Page 20?
Page 18, my lord.
18. How do you establish your link with Horan Biswas?
My lord, as this states, my lord, fairly submitting, my lord, I have no case, my lord. If lordship revert this case, then, my lord.
No, we would
may
have,
depose before the tribunal.
that is why we are asking what is the prima facie document to show that you are a citizen of India. Though that will not be a proof in this forum, we can think of a remand. But we have to be satisfied that there are materials which perhaps can be re-examined or examined. There is not a single document. This is not a case of Horan Biswas. This is a case of
Sosin
Biswas.
my lord.
Any school certificate, birth certificate,
No, my lord.
Nothing?
No, nothing, my lord.
Foreign citizen বলে কইছে
These 45 years of prohibition, whether this foreign is this and how do you know? Best you try under CA.
My lord,
Only option, best option.
একটু কেন করবে
right?
এই বুঝি না পারে এক্সামিনেশন সেটা তো আমাদের জীবনে কি বলবো কি হোক ডকুমেন্ট
In fact, my lord, though the petitioner did not insist, tribunal itself tries to get some documents from the authorized.
Yes.
No, my lord, it's verbally submitted, my lord.
Verbally submitted, But despite of that, madam.
There is no petition, my
The
lord.
tribunal was very benevolent,
But my-
not only considerate,
my lord,
benevolent.
That's not true, my lord.
They have, tribunal has tried to get some report from the agency of this matter. If there is something, they, madam, but no, there is a shift. Even the deputy commissioner, chief secretary.
For all.
Written submission is, written statement is filed.
Register file, my lord.
Tribunal wrote to the chief secretary also.
Yes, my lord.
What else can the tribunal do?
To authenticate the document which was submitted in WS Xerox copy of the bill. Even in evidence, they did not brought it. They were asked to submit the original, they did not submit it. Then-
Originally exhibited some other cases, my lord.
And tribunal insists, the tribunal done themselves, my lord, to inquire about the document.
So, my lord,
Can you get the
check-
benefit of CA?
My lord, only my humble submission, my lord. Let my lord revert this matter, my lord.
We would have
At
reverted
least
if,
one
if,
task may given, my lord.
if
I know
there
it is
would
my
have
evidence, my
been
lord.
any document, no document.
What difference it would have made?
My lord, what happened, my lord? All these present cases are in respect of my brother, my lord. The remaining cases are my lord, my brother. There is initially there is a proceeding against my father also, my lord. The father declared Indian citizen, my lord. My father executed held it in the year 1970, my lord.
Where are those?
My lord, those are in this writ petition, my lord.
Not in the writ petition. Where are those in
My
your
lord,
written
my lord,
statement?
may come to page
Written
20.
statement. State in your written statement.
No, my lord.
Then, in absence of pleadings, how do you?
It was stated that in the year 1961, late Horendra Biswas registered his name as the national Indian citizen before the election office of the Nagaon, district Nagaon. That was my lord. My lord, it is stated, my lord, that my father executed sealed it in the year 1970, my lord.
We are only looking for a link with you and your father. That's all.
My lord, I admit, my lord, that
What are those dates? Which page of the records? Where tribunal had given number of dates?
Order number dated
Page number 4C, madam.
4C.
Order dated 34/2007.
34/2000.
70. Thereafter, my lord, numbers of. Then also, 8C, page number 8C, also, madam. 25/9/2018.
25/9?
18. Okay. Between there are numbers of orders.
Okay.
So they were allowed to ask evidence.
কিন্তু কাম করবো একটু ফিনিশ করে ফেলি stated judgment is here. Statement for the petition. 52 committee to the return to separate petition with the deal with the numerous chance with the time is not explaining justification one. And section is not different. Option. It will into for the others. Okay, we'll do one thing. So far as Hassan's case is concerned, we have completed our hearing, but we are not reserving for judgment because the other petitioners, they claim to be the brothers. So we'd like to see whether there can be a consistency in our, and depends on the order of the reference court also, I mean the tribunal also. Okay, so the other case we'll have it tomorrow. Your part is over, okay? The hearing so far as WPC 7071 has been substantially done. List again for further hearing. List for hearing of the analogous cases. List again for hearing of the analogous cases tomorrow.
My lord. Obliged, my lord.
Okay. Okay, rest. May not we have the time. Sister has a single bench. I will lie down.
Six to a meter, fifth, non-application, fifth, six to a meter.
Six to আমি লিখে দিন। এক মিনিট। এইটো এনেকে থাকো দেই, কালি এইটো কন্টিনিউ কৰিম। ये अभी मार दीजिए, हाँ? Rest date should be given if there is some urgent matter.